All right. Be seated. What's that? Yeah, I changed.
The interpreter still has, there's no one available right now. I'll let you know when they log on.
All right. Some help. This is the 2 p.m. initial appearance calendar for June 15th, 2026. The court's orders for the taking of DNA and fingerprints that were given on the first calendar of this month shall apply to all matters on this calendar. This is victim's rights advisement. If you are the victim of a crime of the case pending before this court, you are advised that you have rights under Arizona law that, among others, include the right to be treated with fairness, respect, and dignity, to a speedy trial, to be present at court proceedings, choose whether or not to be interviewed by the defendant or the defendant's attorney, to be heard before the court makes a decision on release, negotiation of a plea, scheduling and sentencing, and to receive restitution from a person who's convicted of causing you loss. If you have not already been provided with a written statement of all victims' rights, please contact the Victim Services Division of the Prosecutor's Office. I'm Commissioner Aragon. I'm your initial appearance judge. This is your initial appearance hearing. The court will decide whether you're going to be held or released. If you are released, I will advise you of the conditions of your release. I will not be providing every detail. I will not be telling you every detail of your release. All of the conditions of your release will be in writing in your paperwork. I will advise you of why you were arrested. I will not be deciding whether you are guilty or not guilty of those charges. You have the right to remain silent. We are recording everything that is said at this hearing. Please do not discuss the facts of your case because it could be used against you in the future. I only need to find probable cause of the allegations that you've been charged with in this hearing. If I do not find probable cause in any or all of your charges, that does not mean that those charges will be dropped. In deciding your release, I would be considering the charges that you were brought in today, your past criminal history, and your history of showing up at court. I will also be providing a public defender if you qualify. I will provide you with your next court dates. When I call your name, please go to the podium. I will call the person who is appearing next to have a seat outside of the door. So first up, we have Kaylin Arvizo. To the podium, please. And next is Akun Makelwi. Please have a seat outside the front door. Can you state your full name and date of birth, please?
Yes, 1/20/94, Kaylin Arvizo.
Okay, Mr. Arvizo, you are here on two matters. You are here on a Superior Court bench warrant and a new case. I'm going to go over your new case first and then the bench warrant. You're here on one count of aggravated domestic violence and one count of assault with intent to injure. The domestic violence charge is a Class 5 felony. The assault with intent to injure is a Class 1 misdemeanor. I am providing you with a public defender. Excuse me. Your next case dates are June 19th at 8:31 at Superior Court. You have an evidentiary hearing at June 22nd at 1:30 p.m. at Superior Court, and a preliminary hearing on June 24th at 8:31 in the morning at Superior Court. In this matter, you are not bailable as you are on felony release. Second case is your Superior Court bench warrant, and you are here on a warrant related to endangerment, a Class 6 felony. I'm providing you with a public defender. On that case, your next hearing date is June 22nd at 8:30 at Superior Court. In that matter, I'm setting a bond amount at $2,000, but understand on your other case, you're not eligible, so don't post the $2,000 because it's not gonna be any good.
Okay.
Okay, and the conditions of your release on both matters are you are not to return to the scene of the alleged crime, you are not to contact any alleged victims or witnesses or arresting officers. You may not reside at the same location as any alleged victim. You are not to possess any weapons, possess or consume any drugs without a prescription, do not drive without a driver's license, do not leave the state, and you must notify the court of any new address. You must obey any terms of orders of protection and injunctions against harassments. Do you understand?
Yes.
Okay, please take a step to your left and gather your paperwork. Akun Mekelwi to the podium, please. And Nanvit Sanka, you're on deck. How do you say your last name, sir?
So Sean McAwee.
McAwee, okay. Sean McAwee, okay. All right, Mr. McAwee, can you please state your full name and date of birth?
Sean McAwee, March 5th, 2005.
Okay, so you're here on two matters. One is a probation violation. And the other matter is a new court case related to possession of a weapon by a prohibited person, a class 4 felony, carrying a deadly weapon, and failure to admit to police officers that you have that weapon, a class 1 misdemeanor. So, let's see. On probation violation warrant, I am providing you with a public defender. You have a probation revocation hearing on June 22nd at 8:30 a.m. at Superior Court, and a possible disposition hearing at that same date and time. You have a secured bond amount, and that amount of $10,000. On the other matter, that's the possession of weapon by a prohibited person, class 4 felony, carrying a deadly weapon, failure to admit, class 1 misdemeanor. Again, I'm providing you with public defender. You have a status conference on that at 8:31 a.m. on June 22nd, Superior Court, and a preliminary hearing on June 24th at 8:30 a.m. also in Superior Court. I'm going to set a placeholder bond in the amount of $50. Conditions and restrictions of your release for both matters are you are not to return to the scene of the alleged crime, contact any victims, witnesses, or arresting officers. Do not possess any weapons, possess or consume any drugs without a valid prescription. Do not drive a motor vehicle without a valid driver's license. Do not leave the state. You must notify the court of any new address and contact your probation officer within 72 hours. You understand?
Yes, sir.
Okay, please take a step to your left and gather your paperwork. Okay. Okay. We're going to go out of order here. Just stay right there. Okay. I need to see Iro Chun Ramos, please, to the podium.
You put it on here and close it out. So you think dog should be close.
On Mr. Ramos? Okay. Okay. Do we have the interpreter on the line?
Yes, Your Honor.
Okay. Okay, Mr. Ramos, can you please state your full name and date of birth?
Pedro del Sargent Ramos,
And your date of birth?
3 de octubre del 2004.
October 3rd of 2004.
Okay, okay, great. Mr. Ramos, you are here on two counts. One is a aggravated assault, class 3 felony, and criminal damage, class 6 felony. I'm providing you with a public defender. One moment.
Because I told the number, proceedings and changes to the method.
But I don't need to, sorry.
Yes. That's done.
Oh, okay. All right, Mr. Ramos, I'm providing you with a public defender. Your next court hearing is on June 22nd at 8:31 at Superior Court. You have a preliminary hearing on June 24th at 8:31, also at Superior Court. I'm setting a bond amount in the amount of $1,000, and I'm instructing you to get pretrial services before you're released. You will get an envelope with the information on the pretrial services and what you need to do before you're released. Now, the conditions and restrictions of your release are you are not to return to the scene of the alleged crime. You are not to initiate any contact with any victims, witnesses, arresting officers, and you may not reside at the same location of any victim. You are not to possess any weapons. You are not to possess or consume any drugs without a valid prescription. You are not to drive without a valid driver's license. Do not leave the state. You must notify the court of any new address. And you must obey the terms of any orders of protection and or injunctions against harassment. Do you understand? Okay, please take a step to your left. I'm gonna put them in that order. So give me a second.
Have a seat. Have a seat.
What about, so on my screen, the release for showing DNA as well.
Oh, it is. And you,
So I need to take that off, right?
and then we'll use it.
Okay. Okay, we're good. Do you want him to come up?
And then your first one.
Okay. Mr. Interpreter,
Yes, Your Honor.
can you please make the announcement for the gallery just to see if anybody else needs an interpreter, please?
Of course. ¿Hay alguien más presente que necesite la ayuda de un intérprete en español?
Okay, nobody. Thank you for your service today.
Thank you. Have a good one.
Okay. Nanvit Sanka to the podium, please. And Keen Garcia, have a seat outside the door. Mr. Sanka, can you please state your full name and date of birth?
Navneet Sanka, July 7, 2006.
Okay, Mr. Sanka, you're here on 8 counts, 2 counts each. One of unlawful flight from a law enforcement officer, class 5 felony, reckless driving, class 1 misdemeanor, criminal trespassing in the 3rd degree, class 3 misdemeanor, and exceeding the posted speed limit over 20 miles per hour, a class 3 misdemeanor. I'm providing you with a public defender. Your next date will be June 22nd at 8:31 at Superior Court. You have a preliminary hearing on June 24th, again at 8:31 Superior Court. I'm setting your bond amount at the amount of $2,000. You're not to return to the scene of the alleged crime, contact any victims, witnesses, or arresting officers. You're not to possess any weapons, consume any drugs without a valid prescription. You're not to consume any alcohol. You are not to drive without a valid driver's license. Do not leave the state, and you must notify the court of any new address. You understand?
Yes, sir.
Okay, and I'm going to give you a little advice. I read what's alleged. I'm not here to decide whether or not you did it. I know the appeal of driving fast, and I noted in the description that you have a BMW. I've got more than one, and I know how good they are, and I know how stable they can be. But if you're going that fast and you, for instance, blow a tire, you lose control.
Yes, sir.
And if you lose control and hit somebody and it causes them severe harm or death, then you're going to be in front of me on a murder charge. The reason I know that is I have a cousin who's in jail right now for that exact reason.
Yes, sir.
There are plenty of places around here that you can go fast. There are plenty of tracks around here you can do that. You can join the BMW club, and they have track days, and it's a lot more fun.
Yes, sir.
So I don't want to see you here again.
Yes, sir.
So please turn to your left and pick up your paperwork.
Thank you.
You're welcome. King Garcia, to the podium, please. And Victor Kaplan, you're on deck. Okay, Mr. Garcia, can you please state, your full name and date of birth?
Kenny Lewis Garcia, July 2nd, 1989.
Is that July 2nd?
Yeah.
Okay. You're here on one count of possession of drug paraphernalia. I'm providing a class 6 felony. I'm providing you with a public defender. Your next case is going to, or your next hearing on this matter is going to be June 22nd at the Superior Court at 8:30 a.m. and a possible disposition hearing at that same time. I'm putting a secured bond amount in the amount of $500. And your conditions of release are as follows. You are not to return to the scene of any alleged crime. You're not to contact any victims, witnesses, or arresting officers. You're not to possess any weapons. You're not to consume any drugs without a valid prescription. You're not to drive a motor vehicle without a valid driver's license. Do not leave the state. You must notify the court of any new address. I understand you're currently on probation, so contact your probation officer within 72 hours. Do you have any questions?
Can I get the number for that probation officer?
That information should be in your paperwork.
All right. That's it.
Turn to your left, yeah, and get your paperwork. Thank you. Victor Kafan, you're next. And Robert Martinez, you are on deck. Mr. Kafan, can you please state your full name and date of birth?
Victor Anthony Capon, 10/24/1978.
Okay, sir, you are here on a probation violation, class 4 felony related to possession of narcotic drugs. I'm providing you with a county public defender. You have a probation revocation hearing on June 22nd at 8:30 in the morning at Superior Court and a possible disposition hearing at that same time. I'm setting a bond amount in the amount of $250. You are not to have any contact with any victims, witnesses, or arresting officers. Do not return to the scene of any alleged crime. You're not to possess any weapons, possess or consume any drugs without a valid prescription. Do not drive without a valid driver's license. Do not leave the state. You must notify the court of any new address, and you are currently on probation, so contact your probation officer within 72 hours.
So I could bond out, Your Honor?
You can post $250. Okay, turn to your left, please, and get your paperwork. Robert Martinez to the podium, please, and Ricky Perry, you are on deck. Mr. Martinez, can you please state your name and date of birth?
My name is Robert Martinez. My date of birth is 11/11/1973.
Okay, so you are here for driving on a suspended license. I am providing you with a public defender. You have a court date at West Mesa Justice Court on June 18th, 2026. I've set a bond in the amount of $500 in your matter. You're not to return to the scene of any alleged crime. You're not to contact with any victims, witnesses, or arresting officers. Do not possess any weapons. You're not to possess or consume any drugs without a valid prescription. Do not drive a motor vehicle without a valid driver's license. Do not leave the state. And you must notify the court of any new address. Since you're on probation, please contact your probation officer within 72 hours. You understand?
Mhm.
Okay, please take a step to your left, sir, and gather your paperwork. Robert Perry, or Ricky Perry, I'm sorry. And Travis Heyer, you're on deck. Mr. Perry, can you state your full name and date of birth, please?
Ricky Lynn Perry, October 25th, 1976.
Okay, Mr. Perry, before we get into a couple things you're here for, are you on probation right now?
No.
You're not, okay. All right, you're here on two matters. You're here on a Superior Court arrest warrant and a new case. We're going to go over your new case first. You're arrested for dangerous drug possession, a class 4 felony, and possession of drug paraphernalia, class 6 felony. I'm providing you with a public defender. Your next hearing date will be June 22nd, 8:30 in the morning at Superior Court, and a preliminary hearing on June 24th, 8:30 at Superior Court. I'm providing a placeholder bond in the amount of $50 for that case. In your other case, you have a Superior Court arrest warrant for 2 counts. One is possession of drug paraphernalia, Class 6 felony, and possession of dangerous drugs, Class 4 felony. In that matter, I am providing you with a public defender. Your next court hearing on that matter is June 22nd at 8:31, which is a status conference, and a preliminary hearing at 8:31 on June 24th, also at Superior Court. Your bond amount in that matter is $500. For both of those, you are not to return to the scene of any alleged crime, have any contact with any victims, witnesses, or arresting officers. You are not to possess any weapons, possess or consume any drugs without a valid prescription. You're not to drive a motor vehicle without a valid driver's license. Do not leave the state, and you must notify the court of any new address. Do you understand?
Yes.
Here you left, sir, and get your paperwork. Travis Heyer to the podium, please, and Trayvon Harleston, you're on deck. Mr. Heyer, can you please state your full name and date of birth?
Travis Hire, 5/19/2000.
Okay, Mr. Heyer, you are here on 4 counts of threatening and intimidation and threatening to damage property. All 4 of those counts are Class 1 misdemeanors. Your next court date is June 18th at 8:31 a.m. at the Arrowhead Justice Court.
Okay.
I'm setting a bond amount in the amount of $500 and referring you to pretrial services, okay? You must contact pretrial services. There's going to be an envelope that you're going to get, and I'm instructing that you contact them within 72 hours after release. You can make bond. You may not go to the scene of any alleged crime, okay?
Okay.
Do not contact any victims, witnesses, or arresting officers. Do not possess any weapons. Do not possess any drugs or consume any drugs without a valid prescription. You're not to drive a motor vehicle without a valid driver's license. Do not leave the state. You must notify the court of any new address, and you must obey any orders of protection or injunctions against harassment. You understand?
Yes, I understand.
Okay, sir. Take a step to your left.
Can I ask a question?
Sure.
Am I getting released or am I going to jail today?
Well, if you can post the bond in the amount of $500, you can get released.
Okay, thank you.
Okay. Gather your paperwork, please.
All right.
Jaylene Fison and Eli Soto, you're on deck. I'm sorry. Trayvon Harleston. Jaylene Fison, you're on deck. Thank you. He got me. I went out of order. All right, Mr. Harleston, can you please state your full name and date of birth?
Trayvon Halston, Deontay, 08/30/2001.
Okay, so you're here on a justice court warrant out of the Alva Free Justice Court. You're here, that warrant is for driving with a suspended or revoked license, Class 1 misdemeanor. I'm providing you with a public defender. Your next court date will be June 17th at 8:30 at the Alva Free Justice Court. I'm putting a bond in the amount of $500. You're not to return to the scene of any alleged crime. You're not to have any contacts with any victims, witnesses, or arresting officers. You're not to possess any weapons. Do not possess or consume any drugs without a valid prescription. Do not drive a motor vehicle without a valid driver's license. Do not leave the state, and you must notify the court of any new address. Do you understand?
Yes, sir. Your Honor, I got a question.
What's that?
I went to court in February, it was like February 20th, and I signed for, it paid for fines. I don't know how I got a warrant for that. And I already went to court for that, for Avondale. I've been in court and everything for that. I have the paperwork, they fined me and everything. And they said I got a warrant. That don't make sense.
Well, right now you have 3 open cases.
Yeah, but besides that, I'm in custody for that.
Okay.
But I went to court in February for that when I got pulled over and, they took my car and I went to court for that in Avondale. And I seen the judge, they OR'd me and they gave me a fine and I paid for it. I have all the documents at home and everything. My mama, she could get all the documents and whatever you guys need. But I already went to court for that. That's what I'm saying. And I was supposed to bond out today from my other case. And now they said I got a page 2 for this, and I already handled this.
All right. So here's the problem. Because you have not closed the most recent case,
you said you were supposed to bond out today for that one.
Yeah,
It's still open.
yeah, I
That's the
know.
problem.
It's in a process.
It's not closed and I can't do anything about it.
But if I
If it was closed and if you have the paperwork, then you can present that at your hearing. Or you can post bond, the bond amount's 500 and then take that down to the court. It's the best I can do. You understand?
yeah,
Okay, please take a step to your left and gather your paperwork. Jaylene Faison and Eli Soto, you're on deck. Can you please state your full name and date of birth?
Jalen Faison, May 28, 95.
So it's Jalen, not Jalen.
Yeah,
Sorry about that.
All good.
Okay, so you're here on two matters, Mr. Faison. One is probation violation, and the next one is a new case, dangerous drug possession, a class 4 felony, and possession of drug paraphernalia, class 6 felony. We're going to do that one first. So I'm providing you with a public defender. Your next hearing date on that is June 22nd at 8:31 in the morning at Superior Court. You have a preliminary hearing on June 24th at 8:30 a.m. also at Superior Court. I'm putting a placeholder bond in that matter in the amount of $50. For the probation violation, you have probation violation related to possession of narcotic drugs and possession by a prohibited person. I'm providing you a public defender in that matter. Your next hearing date on that is probation revocation hearing on June 22nd, 8:30 at Superior Court, and a possible disposition hearing at that same time. Your conditions and restrictions of release for both are you are not to return to the scene of any alleged crime. You're not to have any contact with any victims, witnesses, or arresting officers. You are not to possess any weapons. You're not to possess or consume any drugs without a valid prescription. You're not to drive a motor vehicle without a valid driver's license. You do not leave the state. You must notify the court of any new address, and you must contact your probation officer within 72 hours. You understand? Okay, please take a step to your left and get
So, hold on, I have a question. I don't have a bond on the probation violation yet.
The bond on your probation violation was $400.
Okay.
Okay. The bond on your new case is $50.
Okay, all right, thank you.
You're welcome. Eli Soto to the podium and Jedediah Ringet. Have a seat. So, Mr. Soto, you're here on a Superior Court arrest warrant for possession of marijuana, class 6 felony. And I noticed that this was really old.
Yes, Your Honor.
So I'm not sure what's going to happen moving forward with all of this. I am providing you with the public defender, and I'm going to tell you when your court dates are. Your next court date is June 30th at 2026 at 8:30 in the morning. You have a preliminary hearing on July 2nd at 8:31. Make sure you show up to those, okay? Because I'm releasing you on your own recognizance. All right?
Yes, sir.
And you've got a little, gosh, dang it. Gotta change this. Hold on a minute. I have to change this, officer. Okay, can you reprint that, please, Katrina? Okay. I'm releasing you on your own recognizance. You're not to initiate any contact with any arresting officers. Do not leave the state, and please notify the court of any change of address. You understand?
Yes, sir.
Okay. They're printing up your paperwork right there. Let's do it. Okay, get your paperwork from the officer and have a seat. Jedediah Ringet, podium, please. Mr. Ringet, can you state your full name and date of birth?
Jedediah Ringet, 3805.
Okay, Mr. Ringet, you are charged with discharging a firearm in the city limits, class 6 felony. Providing you with a public defender. Your next court date is going to be June 30th, 2026 at the Superior Court. You have a preliminary hearing on July 2nd at 8:31, also at Superior Court. Make sure you go to your hearings. You're going to get a copy of all that. I'm releasing you on your own recognizance. You're not to initiate contact with any arresting officers. Do not leave the state and notify the court of any change of address. Understand?
Yes, sir.
Okay, please take a step to your left and gather your picture. Okay, the final case that we have on the docket today is Susan Koch. I understand that Ms. Koch is unavailable to appear today. Ms. Koch has allegations of narcotic drug possession, a class 4 felony, drug paraphernalia, possession of drug paraphernalia, class 6 felony. I'm providing her with a public defender. Her next court date will be June 30th at 8:30 a.m. at Superior Court, and a preliminary hearing on June 2nd also at Superior Court. I'll be releasing Ms. Koch on her own recognizance, and I will go over her conditions and restrictions on release at her cell. Okay, so we are concluding the initial appearance docket for 2 p.m. on June 15th, and we stand in recess.
All right, everyone, please be seated.
Gonna personally show it to you, when, you know, so if I'm, close the door when I come back, or you understand, when I open the door, I'll be here. I gotta take care of a bunch of things.
No interpreter matters?
Yeah, but it looks like the headset got disconnected, so I need the headset back.
You're gonna have to take care of that? Okay. And how's,
Can you bring me the headset? It looks like it got disconnected.
okay. And Mr. Nerman knows it could be last, is the prosecutor appearing virtually on his?
You can bring.
No, I mean the prosecutor.
I believe she can. She usually comes in person.
She will be in person? Okay, she knows to come in at the end also, okay. All right. All right. All right, good evening, everybody. This is the 5 o'clock calendar on June 15th, 2026. The court orders for the taking of DNA and fingerprints that were given on the first calendar this month shall apply to all matters on this calendar. When I speak to you, I'm going to give you some of your release conditions, but not all of them. They will be on your paperwork. So you'll be responsible for reading them. At a minimum, it'll say, don't drive without a valid driver's license and no drugs without a valid prescription. If I do set a security appearance bond, you can go through a bondsman. It's my understanding they do collect calls. Their names and numbers of bonding companies are on some of the walls of the jail. If you can't find them or if you need assistance, ask one of the officers for help. So we're not. So you don't want to do the interpreter matter first?
Yes.
You do? Is the interpreter on the line?
Yes.
Okay. Will the interpreter please identify him or herself, please?
Yes, Your Honor. Good afternoon. Ricardo Parra, Spanish Court Interpreter.
Thank you. Lorena Rascon? Okay.
Yes.
All right. Your name and your date of birth, please.
Lorena Aide Rascón, diciembre 1, 1974.
Lorena Aide Rascón, December 1st, 1974.
Is Spanish your primary language?
Sí.
Yes.
Okay. Do you need the assistance of a Spanish interpreter to help you understand all your proceedings against you?
Sí.
Okay. So I
yes.
will appoint the office of the court interpreter, and they will provide a Spanish interpreter for all the time in court and any assistance to help you in communicating with your lawyer.
Gracias.
Thank you.
All right. You are charged with theft of means of transportation, possession of drug paraphernalia, and driving with a license suspended or revoked. I am appointing a lawyer to represent you.
Gracias.
Your court dates will be
Thank
at
you.
170. Your court dates will be at 175 West Madison Street in Phoenix.
¿Me podría
It
repetir?
will be at 8:30 in the morning for a status conference on June 22nd and a witness preliminary hearing scheduled for June 24th, both at 8:30. Strike that. Your court dates are June 30th at 8:30 for a status conference and a witness preliminary hearing on July 2nd at 8:30.
Okay.
You must be present at all your court dates, or else a warrant will issue for your arrest.
The prosecutors were asking for well, strike that. You are not to initiate contact with any alleged victim or victims. You are not to possess, consume any drugs without a valid prescription.
Got it.
And you are not to drive a motor vehicle without a valid driver's license.
De lo que me está diciendo, nada más lo que no tenía licencia es lo único que hice. Lo demás no hice.
From the things you're saying, the only thing that is true is that I did not have a driver's license. The other
Okay.
stuff I didn't do.
No. These are general release conditions.
Okay.
All right, the prosecutors were asking that I impose a bond of $5,000. However, I am not going to do that. You will be released to the supervision of pretrial services, and you must report to them within 72 hours of your release. You're going to be given a packet by the officer. I want you to read it so you know how to contact pretrial services. It should be in Spanish.
Gracias.
You'll be released from custody.
Thank you.
It'll probably be take about 4 to 6 hours for you to be processed and released. But make sure you contact pretrial services and show up for court as directed.
Claro que sí. Muchas
Okay.
gracias.
To the interpreter, could you just make a general announcement to make sure there's no one else who needs an interpreter? Thank you.
Of course, Your Honor. Soy el intérprete judicial. Buenas tardes. Si necesita asistencia en español para su audiencia, por favor, levante su mano.
Anyone?
Oh, yeah, I do.
What?
I don't see any hands.
Neither do I. Okay. Very good. Thank you very much. We appreciate it. You have a nice evening.
Thank you, sir.
Okay. I also should note that this is procedure is being streamed, so we always read the victim's rights advisement. If a person is a victim of a crime with a case pending before this court, they're advised they have rights under Arizona law that, among others, include the right to be treated with fairness, respect, and dignity, to a speedy trial, to be present at court proceedings, choose whether or not to be interviewed by the defendant or the defendant's attorney, to be heard before the court makes a decision on release, negotiation of a plea, scheduling and sentencing, and to receive restitution from a person who's been convicted of causing your loss. If you have already not been provided with a written statement of all victims' rights, please contact the Victim Services Division of the Prosecutor's Office. Okay. Daniel Perez. So your name and your date of birth, please.
Daniel Ray Perez, 12/27/1995.
All right, sir. You are charged with domestic violence charges of threatening and intimidating and disorderly conduct with a weapon. I am appointing a lawyer for you. Your court dates will be at 175 West Madison Street for a status conference on June 22nd at 8:30, and a witness preliminary hearing at this point is scheduled for June 24th at 8:30. You are not to return to the scene of alleged crime. You're allowed one civil standby with a police officer to collect your essential belongings. You shall not have any contact with the alleged victim. You are not to possess any weapons. The prosecutors were asking for a bond of $50,000. I'm setting a secured appearance bond of $10,000. If you post your bond and you don't show up, you could lose your bond and a warrant would issue. Step to your left, please. Violet Hart. Your name and date of birth, please.
Violet Jane Hart, March 10th, 1991.
All right. You are charged with aggravated assault, a class 3 felony. I am appointing a lawyer for you. You will also be at 175 West Madison Street for a status conference on June 22nd at 8:30, and a witness plum hearing on June 24th. You're not to have any contact with the alleged victim, no weapons. All right, and the prosecutors were asking for a $50,000 bond. I'm setting a security appearance bond of $10,000. If you post your bond, make sure you show up for court, or else a warrant will issue and you could lose your bond. Step to your left, please. Alfonso Collins. Oh, yeah, evening, I'm sorry. Sir, your name and date of birth, please.
Alfonso Collins, 2563.
Okay, I gotta explain something to you in regard to your case. Yours is a grand jury indictment warrant. Okay, it's for acts alleged to have occurred on April 1st, 2018. Okay. I'm just, grand juries are done in secret, so that's why I understand why you may or may not have known about the actual charge. Okay, that's why I want to explain that to you. Okay, you are charged with possession of a weapon by a prohibited person, a class 4 felony, a DUI, and alcohol, drugs, or vapors, or DUI, drugs, or metabolite. The weapons charge is class 4 felony. The other two are class 1 misdemeanors. I am appointing a lawyer for you. All I know is there's indictment. I don't know anything about the facts of the case, so I'm just telling you. That's for you. Your lawyer will have that information, and he or she will explain it to you. All right. Your not guilty arraignment will be at 175 West Madison Street on June 23rd at 8:30 in the morning. You're not to possess any weapons and no alcohol. You can't possess or consume any alcohol. And another judge, upon the return of the indictment, set bond for you and a security appearance bond of $10,000. So you can go to a bondsman. All right. Step to your left, please, sir. Isaiah Springay. All right, sir, your name and date of birth, please.
Isaiah Anthony Springay, October 21st, 2000.
Okay. Okay, sir, you're here on a probation violation. And give me 1 second. I just want to double check something. You're here on one probation violation. You know what the charge you're on probation for, right?
Correct.
Yeah, okay. I won't mention it. You'll be at you'll be at a different court than the other folks, 201 West Jefferson in Phoenix, right across the street from the other one. That's where they do probation violation hearings. The probation violation revocation arraignment hearing will be June 22nd at 8:30. If you are able to get out, because apparently you're an IPS.
Correct.
So you have to contact your probation officer within 24 hours of release. You're not to have any contact with any alleged victims, no weapons, no alcohol, and no drugs without a valid prescription. And a judge down in probation violation court set bond for you and a security appearance bond of $2,500. So if you post your bond, make sure you show up for court so you don't lose your bond and issue a warrant, and also contact your probation officer within 24 hours of release. Okay,
sir.
Step to your left, please. Julio Moreno. Mr. Springay, I didn't mention this to you. Never mind. Yeah, 1 second.
Should I step out?
Oh, 1 second. No, you can do that. Mr. Springay, these are the terms. You're alleged to have violated terms 2, 3, 4, 7, 14, and 15. Okay, just want to let you know. And I just have to make that adjustment on the thing. I don't think I have it on there. No, I didn't have to. I have to edit it, by the way. You can stay there, sir, by the way, just so you know. Now I got it. Okay. All right, sir, your name and date of birth, please.
Julio Cesar Ruiz Mariano, 03/23/95.
You also are here on a probation violation, and you know what you're on probation for, right?
Yes, sir.
Okay. I appoint a lawyer for you. Your revocation arraignment hearing will also be at 201 West Jefferson in Phoenix, June 22nd at 8:30. You're alleged to have violated terms 3, 5, 7, and 15. If you get out, contact the probation officer within 72 hours of release. You can't possess any weapons, possess or consume any alcohol, and no drugs without a valid prescription. A judge down in probation violation court set bond for you in the amount of a secured appearance bond of $750. All right. Make sure you make it to court if you post bond and contact your probation officer. Step to the left, please. Mariah Montenegro. All right, your name and date of birth, please.
Mariah Montenegro, 03/28/95.
What was the date of birth?
03/28/95.
Okay. All right. You're here also on a probation violation. You know what you're on probation for?
Yes.
Okay. I'm appointing a lawyer for you. You'll also be at 201 West Jefferson for a probation revocation arraignment hearing on June 22nd at 8:30. You're alleged to have violated terms 3, 4, and 5. Likewise, if you get out, contact your probation officer within 72 hours of release. You can't consume or possess any alcohol, no weapons, and no drugs without a valid prescription. A judge down there in probation violation court set bond for you in the amount of security appearance bond of $500. Okay, step to your left, please. Oh, that's on 2024-103 739-002. In 2023 152-043. Likewise, same court dates, same conditions, and you're alleged to have violated terms 3, 4, and 5, and another $500. So it's a total of $1,000. All right, step to your left, please.
Your Honor, I'm not understanding. Am I going to get released today?
If you post your bond of $1,000 secured appearance bond.
All right.
Okay.
Thank you.
Jared Selsor. Your name and date of birth, please.
Jared James Seltzer, April 9th, 1994.
You've got 2 warrants out of, see which court is it at? Moon Valley. Moon Valley Justice Court. The address will be in your paperwork. Both for warrants on interference with judicial proceedings, and they want. I'll tell you what. They on both of them. They want, and each one that court wanted a $500 cash bond in each for a total of $1,000 cash. I would note. You've been released out of this initial appearance court on May 4th, 2022, June 13th, 2024, and by me in October of 2024. But there's still a problem. I think there's certain requirements you have to do in regard to that, and it's got to stop. And so on each one, I'm setting secured appearance bond, and I'm appointing a lawyer for you for a limited purpose of bond review only, and it'll be $250 each. So your total bond is a secured appearance bond, not a cash bond, of $500. Unless you like him coming back here, I suggest to take care of that situation in Moon Valley. All right, step to your left, please.
Thank you.
Okay. Leonard Romero. All right, sir, your name and date of birth, please.
Leonard Romero, August 3rd, 1989.
Okay, it looks like parole's going to put a hold on you.
Parole?
Yeah.
They're going to put a hold on me?
That's what pretrial service seems to think. It says the parole, DOC notified and will place hold.
Yeah, I get off of parole like in 2 days.
Well, let's put it this way, there's still going to be a hold, and so it may push back the time you're getting out. You'll talk to your lawyer about this. You're charged with taking contraband into a correctional facility, Class 2 felony, possession of dangerous drugs, Class 4 felony, possession of drug paraphernalia, Class 6 felony. I'm appointing a lawyer for you. I will tell you this: the The state wanted a $20,000 bond. I'm making it $250. Okay. No weapons, no alcohol, no drugs. And if you get out, contact your parole officer within 72 hours of release. Okay. And talk to your lawyer about that situation with parole. I'm putting a bond basically to make sure you get credit for both.
All right.
Okay. All right. Step to your left, please. Cameron Richardson.
Richardson?
Yeah. Cameron Richardson?
Right?
No, he's got a beard, glasses. There he is.
He's coming up.
Yeah, that gentleman's with you. We'll just do that last anyway. All right, so your name and date of birth, please.
Cameron Richardson, this is my first, 1994.
You got a warrant out of the Apache Junction Justice Court. It's a different county, and they, it's on a possession of drug paraphernalia. I don't know much about it. I just know it's a different county. So a lawyer will be appointed for the next court date. The address will be on your paperwork for Apache Junction Justice Court. Your arraignment hearing will be June 18th at 8:30, and they set bond in the amount of $256 security appearance bond. That's all I know about it. Okay.
Okay.
Make your bond, push your bond. Make sure you show up down there. Okay.
Okay.
Step to your left, please. Elizabeth Sanchez. Right. Good evening. Your name, date of birth, please.
Elizabeth Sanchez, 122283.
You're here on 2 probation violation warrants, and you know what you're on probation for, right? Did a yes?
Yes.
Okay. I'm appointing a lawyer for you for both, and your court date will be the same at 201 West Jefferson, June 22nd, 2026 at 8:30 for a probation revocation arraignment hearing. You're alleged to have violated terms 3 and 5. If you get out, contact your probation officer within 72 hours of release. You can't possess or consume any alcohol, no weapons, no drugs without a valid prescription. Now, in both of them, a judge down in probation violation court said bond for you about $150 each. So your total bond is $300 security appearance bond. You know what I've said to the other folks, you post bond, show up for court, and contact your probation officer within time limits I've mentioned. All right, step to your left, please. Vincent Schreider. Okay, so your name, date of birth, please.
Vincent Schreider, February 19th, 1990.
All right, you got 2 matters. One is the new charges and one is a probation violation on it. So let's just deal with a new case. Possession of dangerous drugs, possession of narcotic drugs, possession of drug paraphernalia, 2 class 4s and a class 6. I am appointing a lawyer for you. Now, this is important to understand. These new cases will be at 175 West Madison Street, and the probation will be on a different building. They'll ultimately be combined, and you'll charge your lawyer about it. Okay. Your status conference is June 22nd at 8:30. Witness preliminary hearing is June 24th. Now, these following conditions apply to both: no weapons, no alcohol, no drugs without a valid prescription. If you get out, contact your probation officer within 72 hours of release. That applies to both. Bond is set in the amount of $150 on that security appearance bond. And your probation violation, you know what you're on probation for, correct?
Yeah.
Okay. Here's the thing: you'll be at 201 West Jefferson for a revocation arraignment hearing on June 22nd at 8:30, same time. So tell your lawyer whichever court they take to about the other one, so they don't mistakenly put a warrant, because you can't be in 2 places at once. All right. So make sure work with your lawyers in that. But ultimately, work with your lawyers rather. But ultimately they'll be put in the same court. Okay. All right. And so bond on that is also $150. You're alleged to have violated term 1, so your total bond is $300 security appearance bond. All right. Step to your left, please.
Is it possible that I don't have a bond?
No. Well.
Okay.
Well,
I never had a warrant.
Well, talk to your lawyer about that. They can always try to reduce it.
Okay.
Right.
Thank you.
Daniel Luna. All right, so your name and date of birth, please.
Daniel Luna, November 10th, 2002.
You're charged with possession of narcotic drugs, class 4 felony, possession of drug paraphernalia, class 6 felony. I am appointing a lawyer for you. Don't lose your paperwork. Make sure you make your court dates. 175 West Madison Street in Phoenix. You'll have a status conference on June 30th at 8:30, and your witness preliminary hearing is scheduled July 2nd at 8:30. I'm releasing you to pretrial services for drug testing and monitoring. You'll have to report to them within 72 hours. You'll get a packet from the officer explaining everything and how to contact them.
Yes, sir.
And it'll probably be 4 to 6 hours before you get out, but it's real important. Also, a warrantable issue if you don't contact them and do what you're supposed to do. All right? Step to your left, please. Gary Lynn. All right, sir, your name and date of birth, please.
27/2000, Gary Chancellor.
Gary Lynn?
Yeah.
Okay. You got a warrant out of the Highland Justice Court. If you don't know where it is, the address will be on your paperwork. You spend a few hours here. I assume we'd be better off if you just show up in court there, right?
Yeah.
Well, because I want you to be there on July 2nd at 9 o'clock, the Highland Justice Court. You can't possess or consume any alcohol, and I'm going to release you on your own recognizance. But be smart and show up for court.
Uncle Nate.
All right, but anyway, it'll be about 4 or 6 hours before you get cut loose.
All right.
Okay. All right. Kyle Shepard. Yes, sir. Your name and date of birth, please.
Kyle Seifert, 5398.
You got 2 warrants out of Peoria City Court. The address will be on your paperwork. At least one of them is post adjudication. One is for disorderly conduct. The other one's for possession of drug paraphernalia and failure to obey a police officer. I'm releasing you on your own recognizance of both.
Thank you so much.
But be there on July 6th at 9 o'clock, so you don't have to spend all this time here. I'm sure you don't go anywhere yet. And obviously, the same date for both. And okay, all right, step to your left, please. Adam Goshton. Ms. Sauer, if you need to talk to Mr. Excuse me 1 second. Ms. Sauer, if you need to talk to Mr. Nermer, he's back there.
Okay, no, I know.
Okay, that's fine. All right, because we're going to have a lengthy discussion on that case. All right, sir, your name and date of birth, please.
Adam Lee Ghostin, 4/21/1989.
All right, sir, you've got a warrant out of the University Lakes Justice Court. The address will be on your paperwork. You're charged with criminal trespass in the 3rd degree and possession of drug paraphernalia, both misdemeanors. You have to be there at the University Lakes Justice Court on June 30th at 1:30. You can't return to the scene of alleged crime. All right, just make sure you show up.
Yes, sir.
Okay. I got to make one edit in regard to that. Okay. You'll be at, second. I don't think I told you the court date, June 30th at 1:30. Make sure you show up. It'll be about 4 to 6 hours before you get out.
Yes,
all right.
sir.
Make sure you be smart and show up to that court. Okay.
Yes, sir.
So you don't have to come back here. All right. David Baker.
Go ahead.
And sir, if you want to lean on the podium, I will not be offended. It's okay. All right, sir, your name and your date of birth, please.
David Baker, April 16th, 1956.
You were charged with possession of narcotic drugs. However, based on the limited information I have, I cannot find probable cause. I'm appointing a lawyer for you. Doesn't mean the county attorney's office won't press charges against you. So you got to show up for court. 175 West Mass Street, June 30th at 8:30 for status conference, witness preliminary hearing on July 2nd at 8:30. But, all right, but you'll be out in a few hours, okay?
Thank you, sir.
Step over there. Okay. We're ready on Mr. Henderson's cases. I'm sorry, if you want to slide him know, we're ready.
Sure.
All right. Okay. First of all, sir, your name and date of birth, please.
Travion Henderson, January 11, 2007.
Okay. First of all, here appearances from both counsels, starting with the state.
Ellen Sauer on behalf of the state, Your Honor.
Thank you.
Good evening.
And Mark Zimmer on behalf of the defendant, and say good afternoon, but maybe it is good evening.
All right, either way, okay.
Yeah.
All right, thank you both for appearing right here. And Mr. Nermer, just for the basics, you filed a notice of appearance just doing the booking number, so I assume you're appearing on both matters, right?
I am, Judge. I didn't know there were two different.
It's a probation violation plus a new one.
I didn't know the probation violation had been filed.
Oh, okay. But I'm sorry, I put your name on both, but just the way it has to say he's indigent, so I appointed a lawyer, but having your name as the notice of appearance. Okay, I just left it like that, and so you're listed on both. Okay. Let's deal, first of all, you're on probation for, I think it was aggravated robbery, if I remember correctly, a class 3 felony. Mr. Nermer is going to explain to you how it's in different courthouses, at least initially, and since he's going to represent you on both. The probation revocation arraignment hearing is on June 22nd at 8:30.
Sorry, Judge, I didn't hear that.
June 22nd.
Thank you.
At 8:30. And the new case, which we'll go into in a little bit, it's also June 22nd for a status conference at 8:30 at once at the South Court Tower, and the witness preliminary hearing is June 24th at 8:30. At least that's how it's scheduled. So you'll explain to him, you'll look out for, he can't be at both places at the same time, okay? Obviously, if you were able to get out, you'd have to contact your probation officer within 72 hours. No weapons, no alcohol, no drugs without a valid prescription. Okay. Mr. Nermer, I've known you for a long time. I'm going to give you the benefit of speaking whatever you feel appropriate. Likewise with Ms. Sauer, because given the nature of the charges and the probation violation matter, I'll give you both an opportunity. And so take whatever time you both need. Okay.
I'll just move it back here so we can see each other a little bit.
Okay, fine. And there is a microphone down there, right?
There is a microphone.
Okay. Thank you for mentioning that. All right.
So, Judge, I was
one second before we get to that. The new charges. This is everyone else is gone, right?
Yes.
Okay. Could you actually close the door? Oh, there, officer, you close the door. Thank you. And I'll hear. I want some explanation he's charged with 2 counts of sexual exploitation of a minor, a class 2 felony, alleged to have occurred on May 1st, 2025. And then the other charges are alleged to have occurred on June 10th of this year. Aggravated assault, 2 counts for impeding breathing, 1 count of assault to that's class 4, assault to class 1 misdemeanor, and threatening or intimidating, class 1 misdemeanor, and disorderly conduct, class 1 misdemeanor. I also am aware that he did turn himself in, I think today, right? So I have that information, and so, as Mr. Nermer, the paperwork may say he's indigent and appointing a lawyer, but also your name is a notice of appearance. Okay. Ms. Sauer, would you like to go first? Also, do you have any, are you able to shed light on why the sexual exploitation suddenly got posted today, along with the new charges? I thought that was curious, if you know.
Yeah, I don't have specific information. I thought there was mention in the addendum. I was just scrolling through it right now trying to find it, but I thought there was mention of possibly forensic analysis of the cell phone, which
I'm saying that what they did in
can take some
amended.
time.
Okay, so let me start. Okay, I started saying, did you get a copy of the Form addendum, Mr. Nermer?
I got a 4-page Form 4, so I've got.
Okay, because the reason I'm saying that is because in that Form 4 addendum, I'll call it the addendum.
Okay.
It has the description of the 2026 cases, then another one for the 2025 matters on the same Form 4. So just to set the record or table for that. So I'm sorry for interrupting, Ms. Sauer, in regard to that.
That's all right, Your Honor. There was mention in the addendum about a search warrant for a full forensic examination. I believe, without it specifically saying the exact dates of when that forensic examination was completed, I believe the delay was due to the forensic examination. It does look like the search warrant wasn't granted until, I believe it's October 7th. So that obviously right there was several months, about 5 months later. And then there would be additional time for the forensic analysis.
Okay. I would also say for both the parties, and Ms. Sauer, I've known Mr. Nermer has appeared before me numerous times over the years before I retired. So I will tell the parties, let's put it this way. He was on probation for a serious Class 3 felony, and now these charges. And I think, Mr. Nermer, you're going to want, and I know Ms. Sauer is still speaking, but you're going to want to also spend a bunch of your attention to the probation violation, because you know what the court could do in regard to that. Okay, but Ms. Sauer, because I know Ms. Sauer did send a recommendation to the court, but didn't address the probation violation. But that's quite usual and quite the norm. Okay, so if you want to address the probation violation also, you're certainly welcome to do so.
Well, we have the two different dates of offense. Obviously, the one with the CSAM material that predated the date of the offense predated when he went on probation. As far as the new 2026 domestic violence offenses, that would be a violation of probation. And
well, that's not what the issue in terms of the release conditions for the probation violation is what I was talking about. All right.
I defer to the court on that
okay.
one, Your Honor.
Okay, good. Anything else you want to say in regard to this?
Yes, on the new case, the state had recommended a $150,000 cash-only bond, and that's because of the danger to the community. We have the CSAM material, which the state is significantly concerned about with young underage children. The state believes is a danger to the community, especially minors in particular. And then we have the DV offenses and the Form 4 articulated strangulation, which is an inherently violent offense, which is associated with significant, there's a high lethality associated with DV strangulation. And with the robbery already having a violent prior, the state believes a high cash bond is appropriate based on the totality of all this.
Okay. One other thing also, because the nature of the 2025 charges, I think it's required to have an ankle bracelet if he posts a bond, but he's also on probation. So ordinarily we don't do both. So I think I have to amend that either way in regard to that.
The state would like an ankle monitor and.
I think it has to be, even though he's on probation. Okay. Mr. Nerman, before you proceed, one thing, I'm looking at the pre-sentence report from which he was placed on probation. Okay. According to this, the caller stated that 2 suspects had robbed him at gunpoint, and according to this, one of the assailants came up behind him, placing a chokehold and applied pressure to his neck for approximately 10 seconds. He was then thrown to the ground. The suspect, I assume that's referring, actually, you represented him on that charge also, Marcy.
Yeah, I know the case well.
Yeah,
Very well.
so just for the record, and then punched him to the face and pistol whipped him. Stole his merchandise. Okay, go ahead.
Okay, so I'm gonna take this, I'll address that first, Judge. So if you saw the sentencing memorandum.
No, I didn't. I just looked at the pre-sentence
But at
report.
the end of that case, at the end of the investigation, after all the thorough investigation by the state and the defense, the defendant was stipulated to probation with no jail time as a resolution. He didn't serve a single extra day in jail. So I know that the allegations there sound bad, but in the end, after the investigation was done and the state and the defense talked, stipulation to probation with no upfront jail time. So I think that's important to note, given what the court read, what the court read. I want to address probable cause on each one of these counts, Judge. So it looks like 1 through 5.
Okay, hold on. Let me go back to that.
Yes, sir.
Okay, 5. You're talking about why don't we just call them the 2026 matters?
Okay, the 2025 matters and the 2026. So the 2026 matter. A young lady goes over to my client's house, takes the Uber over there at 10 o'clock at night. She asserts, well, let's talk about her first story. Cops get called out around 1:30, 2 o'clock in the morning. You know how police work. They separate the parties. There was nobody overhearing what one person said, another person said. Their stories matched up. There was a struggle over a phone. She got bopped on the nose by her or by him, but somehow a misdemeanor assault gives her a little bit of bloody nose at worst. 12 hours later, so we're talking about afternoon the next day. Well, let me back up again. So her story is she goes over there, they get in an argument. That's their first story. They struggle over a phone. She gets a bloody nose. The next day, 12 hours later, she calls the police, meets with the police, not 7 o'clock in the morning, not 2 hours after the police got there, but 12 hours later, she calls the police and says, oh, when I got there, he attacked me and choked me. And then I decided to have sex with him, but I didn't really want to, but I had sex with him. And then several hours later, after I'd been there for 4 hours, then he attacks me again and chokes me again. And then he gets me down on my knees and punches me in the face. And what does the forensic examiner find? 2 dots of petechia, however you want to pronounce it, on her neck. Not finger marks, not strangulation marks, not a bloody nose, not a punch in the face, no injuries that would corroborate her new story. The first story is what makes sense. They struggled over a phone. She got popped in the nose somehow and got a little bit of a bloody nose. Not this choking in these class 4 felonies that she came up with over 12 hours later, Judge. So I don't think there's even power PC for these felony charges. Maybe for a misdemeanor disorderly and maybe even a misdemeanor assault if the bloody nose came from his hand. But with no evidence to back up her story, no physical evidence of choking, that we're talking about on probation class 4s here. So this whole conversation is he can be held no bond. That's serious. He's got a job. He's doing, I'm going to jump to the probation. He's doing well. He's been reporting to his probation officer. He's got a full-time job. They visited his house. There's been no problems. When we found out about this, The police officers were looking for him. I called the detective. My client was willing to turn himself in on Saturday morning. I said, let's wait till Monday. I can't do it Saturday morning. So the first thing this morning, we picked him up at his apartment and drove him to the police department and self-surrendered him. If he was such a danger or such a threat, he wouldn't do that, Judge. He's not a danger to this community. He's not a threat to the community. And the allegation that he made a threat towards her, where's the proof of that? Is there a text message? Is there a message of some sort? She just said she made a threat. So that's the 2026 case. 2025 case, Judge. It looks like there's some thumbnail images, not photographs, not videos, but 2 thumbnail images came from it looks like an app called Telegram. I don't know what that is, but I'm guessing it's some kind of communication app that kids use. And someone might have sent him something. He probably didn't even see it. There's no evidence he even saw it, downloaded it. And just on the last note it looks like on the last page, the second to last page, it says a forensic examination pursuant to the search warrant is still pending. So that hasn't even been done. Judge, I think electronic release is appropriate in this case. Electronic monitor on his ankle. That can do, you can do geographic, so he doesn't go anywhere near this alleged victim, which I'm sure he doesn't want to anyway.
Well, there's order of protection in effect also.
Oh, I didn't know that.
Yeah, I believe.
Okay, well, that's great. That's just another, layer of protection that isn't really necessary.
A minimal one, I would know.
Okay, so I asked the court to impose a bond, on the probation violation. And I find that I asked the court not to find even probable cause on the 2025, as far as the felonies are concerned, and on the 2026, because there's no evidence my client ever accessed this, saw this, it came through some kind of app, it looks like. And it's just thumbnails. And if you know what the thumbnails are, that means there's no images. That's what's left over when something went through the phone at some point. Thank you, Judge.
Okay, thank you, Mr. One thing, by the way, when I'm trying to review all the documents all at the same time in regard to this. Apparently, she did record on her phone certain things, and there was certain statements made in regard to it. A lot of Mr. Nurmer, I'm sorry, is you're presenting a trial case right now, and probable cause, is a lot less. I am going to find probable cause in regard to that these matters. And I just want to do one more thing here, just check one more thing here.
Well, then I would like to turn to the bond amount, Judge.
Okay, hold on 1 second.
$150,000 cash.
Hold on 1 second,
Yeah.
I'm just looking for one thing in particular.
There were witnesses in there as well, Your Honor.
You mentioned about how he's doing well on probation. I'm reading APET's notes, by the way. Where is he working?
What's the name of the place, Jerry?
It's called AZ Healthcare. It's a mattress factory.
Okay, the reason being because apparently he was working, I'm looking at the APET's notes. He was working at Walmart but lost his job because of his background. And that was just I think, from a notation from May 6th. Okay. I don't see anything significant in terms of the notes. I went down to about May 6th. Like, go ahead. Because apparently his phone, I know probation and the police were trying to reach him, but his phone is disconnected. So I don't consider that as a negative or a positive thing.
So Judge, he had a job at Amazon all through high school, lost that job when he got arrested in the case he's on probation for. As soon as he got sent to, see his future, he wasn't going to prison, wasn't going to jail, so he got a job at Walmart, lost that job in the background check, got another job at this mattress place. So it's not easy for a 19-year-old convicted felon to find a job, but he's been working on it, and he did. I don't know what the notes say, but I think I'm pretty sure he's doing well on probation. He's working. He has contact with his probation officer. He's not a risk. He turned himself in, Judge. I think the court should really give that a lot of weight when you're talking about if he's a danger, if he's a flight risk, and things like that. So I would ask for about a $10,000 bond on the new charge, and defer to the court on the probation.
All right. Anything else you want to add? Okay.
Yes, Your Honor. The CSAM material, that's a significant concern here. And I would disagree that he's doing well on probation if he's committing new offenses, violent ones at that.
Okay. Obviously, you have to obey the terms of the order of protection that's in effect, or anyone that would be in effect, or any injunctions against harassment. Mr. Norman, I would tell you this. Originally, I said I wanted to spend the time to hear from you, Paul. I was going to set no bond on the probation violation, but I am going to set a bond. Okay, you're alleged to violate term 1 on that, by the way. I know Mr. Nermer has presented a substantial arguments on your behalf. He's represented you in the past, but obviously you're on probation, so obviously the behavior has to be certainly different. I won't use the term Boy Scout, but that's the thought that came to mind. Obviously, no weapons, no alcohol, no drugs without a valid prescription. And alcohol, of course, because of your age. And if you were able to get out, contact your probation officer within 72 hours of release. Your court dates for the probation violation, I already mentioned, June 22nd at 8:30 at 201 West Jefferson. I've decided to set bond amount of $10,000 security appearance bond on that.
On which case, Your Honor?
That's in the probation violation. Now, this brings us to the by the way, according to the Form 4, that's what pretrial services wrote. It said per Form 4, victim currently has an order of protection, which was obtained post-incident. I don't know if it's been served or not. Ordinarily, I went up and that I assumed it was served, but maybe it hasn't been. But if it's served, obviously, you have to obey that. But also, conditions of release is absolutely no contact with her.
Yes.
Obviously, there are issues in regard to at least some of the charges. I think I'm obligated, even though he's on probation, to install, if he posts bond, to install these electronic ankle monitoring. And with the curfew hours from your home will be allowed only during hours permitted by pretrial services. I already told you about contacting probation officer, et cetera. And you'll get a packet, and Mr. Nermer, I know, will explain everything to you in terms of your requirements for that. I am cognizant of the fact you turn yourself in regard to that. There could be one of two reasons why the alleged victim did what she did. Either it wasn't as being alleged now, or number two, because of fear. It's not uncommon in domestic violence cases to have a situation like that, and also there's fear in regard to that. Because there is an ankle bracelet, I am going to set a security appearance bond in the amount of $50,000 in regard to that. As I said, I was very, very close to setting no bond in regard to it. So we are in recess in this matter. What?
It didn't say your signature on it.
Which one?
The new charges.
The new charges? Okay. Okay.
All the paperwork is out, right?
It should be now. All right, we are in recess. Ms. Miller, if you
Thank
need
you.
more time to talk to him, I'm sure the
Yeah,
officer.
should I have 2 more minutes just to explain?
It's up to the officers.
I'll be quick, guys.
Okay.
Thank you. Thank you.
Yes.
We'll just wait for the other folks to come in. Yeah, I'm not going to try to pronounce the name. Start with R.
Yeah. I didn't want to call.
Either do I. And then we have one house call. Yeah, okay.
The guy or the girl?
There's information.
This is something specific. You don't do it. You know what? In one thing.
In the meantime, I'll call the house call. Juliana Bermudez, why was that house call? Why is she a house call?
Able to function in general population,
She just not
disruptive.
disruptive. Okay, thank you. She's got 2 matters before me.
There you go, he's got it.
Both of them were probation violation warrants. And
All right. Thank you.
I'll see you tomorrow.
and apparently we set for non-witness violation hearings. She's on probation for burglary in the 2nd degree, and the other one is drug paraphernalia. Going a lawyer for her, 201 West Jefferson. Court dates June 22nd at 8:30. And bond each one was set at $350. She gets out, contact a probation officer within 72 hours of release. No weapons, no alcohol, no drugs without a valid prescription. All right. Who's covering the 8 o'clock?
You.
No, me.
Oh, I believe Carla.
Carla? Okay. It's not as bad a calendar.
Yeah.
I've done about half of it already. But as I said, I need Lori Kurchenko is going to be there, so I need, by the time we get there, so anything new.
Just ready when you're ready.
No problem. That's why I did the house call, mentioned it first, so. So was that?
You're ready to see this.
Yeah, I'm just waiting to bring the person back. Because the other person was still within separate also from the charges, so. Oh, all right, sir, your name and date of birth, please.
Alexander Ozeki, 10/19/89.
Okay, so you're on a probation violation warrant. You know what you're on probation for, right?
Yeah.
So I don't have to mention it. I'm appointing a lawyer for you. Your next court dates will be at 201 West Jefferson for a revocation arraignment hearing on June 22nd at 8:30. You're alleged to have violated term 13, not self-surrendering at the jail. And if you get out, contact your probation officer in 72 hours of release. And I think you're on lifetime probation, right? Yeah. And you're not possessing any weapons, not consume or possess any alcohol, no drugs without a valid prescription. And a judge down there set bond for you in the amount of $1,000 security appearance bond. So if you get your bond, contact your probation officer and show up for court, or else it'll be a warrant. All right? Step to your left, please. Very good. Off the record. Everyone, please be seated. I'll be a few minutes, I'll call you in when we're ready for you.
I actually need a few more minutes.
That's what I'm saying, so no problem.
Okay.
I have some introductory things to do anyway.
Thank you, Judge.
So. Good evening, everybody. Just the clock calendar. It's June 15th, 2026. I will tell you that the court orders for the taking of DNA and fingerprints that were given on the first calendar of this month shall apply to all matters on this calendar. I'm not going to say out loud all your release conditions. They'll be on your paperwork, so it'll be your responsibility to review them. At minimum, it'll say no drugs without a valid prescription and don't drive without a valid driver's license. If I set bond, secured appearance bond for you, you can go through a bonding company. It's my understanding they collect calls, and it's my understanding their names and numbers are on some of the walls in the jail. If you can't find them or if you need assistance, ask one of the officers for help. Okay. Since this matter is also, these proceedings are also being streamed, I do read the victim's rights advisement. If a person is the victim of a crime with a case pending before this court, they're advised they have rights under Arizona law that, among others, include the right to be treated with fairness, respect, and dignity, to a speedy trial, to be present in court proceedings, choose whether or not to be interviewed by defendant or the defendant's attorney, to be heard before the court makes a decision on release, negotiation with police, scheduling and sentencing, and to receive restitution for a person who's been convicted of causing their loss. If you've not already been provided with a written statement of all victims' rights, please contact the Victim Services Division of the Prosecutor's Office. Okay. Which case is this attorney on? Oh, but he's not ready yet, so, all right. And plus there's an attorney on number 15, and he's a virtual?
Yes.
Okay, and that's in this hearing here, virtually? Okay, let me just, before I would do that, I'll just do number 10. All right. Quentin Howard? Okay, so your name and date of birth, please.
February 9th, 1986, Quentin Michael Howard.
Okay, so you're here on a grand jury indictment. That's probably why you don't know about it, because it's done in secret. Okay, and it's for acts alleged to have occurred on February 2nd of 2024. Right, you're charged with robbery, class 4 felony, and shoplifting, a class 4 felony. You're not guilty of arraignment. Hearing is going to be set at 175 West Madison Street in Phoenix on June 23rd, just a few days from now, at 8:30 in the morning. I did appoint a lawyer for you. You cannot initiate contact with any alleged victims.
Judge, I have a quick question.
Sure.
So I've been in prison for the last year, and they brought me back on an appeal.
Sure.
Is that what this is?
No. Okay, but I have to edit this one thing. I'm going to say.
Because
no, it's totally indifferent. Okay.
Because on February 2nd, year 2024 is the day that this case that I'm on right now is what the same incident happened on that day. So
I don't know.
And
I just filed. So what do you? You're being held on a DOC hold.
Yeah. So
you're not going anywhere because you're in DOC.
So I went to trial for armed robbery with a use of deadly weapon and aggravated assault, which happened February 2nd, year 2024. So I went to trial on that in May of 2025. I got a lesser included offense of
Okay.
robbery.
Okay.
Just real quick, because
Yeah.
I'm trying to make sense of this.
I know, but let me explain to you why I'm cutting you off, because I don't have any of that information.
Like, that's what this sounds like that is, because I went to court today. I went to court this morning with Judge Susan Nichols, and they said they're starting a whole new trial. So I wonder, is this like what that is? Because I got charged with robbery at sentencing last year, and this is the same date. Nothing else happened that day. So,
Okay.
do you get what I'm saying?
I understand what you're saying. I'll tell you what I can look at, because I can look back at the 2024 case. Okay?
Because I'm trying to figure out.
Okay, one second. I'm
All
trying
right,
to
thank you.
look it up for you, okay?
If you can tell me the store location.
One second.
All right.
Okay, the case in 2024 was armed robbery and aggravated assault, alleged to occur on February 2nd, 2024.
Yeah, I got.
1 second.
All right.
Ms. Stetson on the line? Yes. Okay, Ms. Stetson?
Yes, Your
Who's
Honor,
the
state
prosecutor?
present.
Okay, could you do me a favor? First of all, sir, I'm gonna put this over to the next calendar, and I'm gonna ask Ms. Stetson to review this. Were you listening to what, Mr. Howard said?
Yes, Your Honor, the state didn't catch all of it, so,
Okay, because he's saying he went to trial and he appealed it, and they brought him up from DOC, and I looked at the indictment of, because he's saying that, that armed robbery and ag assault occurred on February 2nd, 2024, and that's what, these dates of this indictment are. And I looked at the 2024 open case, and it's armed robbery and, ag assault from February 2nd, 2024. I'm just wondering if it's a mistake and it's not a duplicate. Is there any way you can look that over?
I can definitely see if I can find out any information. I can't guarantee anything, but I can look into it.
Okay, what I'm gonna do, I'm gonna put it over for the 11 o'clock calendar. You'll see another judge, okay?
Tonight?
Yeah,
I mean, I want to go back to my pod. You know what I mean?
well, it's not gonna happen right now, because I'm saying, you want me to, if not, I'm just gonna set the bond
All right.
on this.
All right.
But-
Because I just to let you know, I got a lesser included offense of robbery
Okay.
at trial.
She's listening in right now, so
Okay.
she'll double check, but I'm gonna put on the next calendar, okay? Because there might be some basis of fact, because everything was sealed until it's served in you. I don't even see the indictment. I just have the warrant, okay? So I really can't help you in regard to that.
Is there like a location where this incident?
No, I don't have any, that information, sir,
Nothing.
okay? Let me just check one other thing here. No, I can't find anything now. So the prosecutor will do some checking and maybe she'll have some information for the 11 o'clock calendar. No promises in regards to that, okay? All right, thank you. Okay. All right, so Ms. Stetson, if you can check on that, it'll be, Commissioner Kurchenko is going to be on the bench then, all right?
Oh, yes, Your Honor, I'll do my best.
Yeah, I know, I said, all we can do is check on it, but it's too much similarity, to me to just proceed at this point without further checking. Okay, I'm sorry, he's from Lopez, so there's Mr. Navas on the line, right?
Yes, I am, Your Honor.
Okay, just want to make sure. Okay, this is the Zachariah Haza. So 10, you'll put at 11 o'clock and up. Okay, sir, your name and date of birth, please.
Zachariah Hazel, 09004.
Okay, and can I have appearances of both attorneys, starting with the state, please?
Yes, Your Honor. Good evening, Ashley Stetson on behalf of the state.
Good evening, Your Honor. Armando Nav on behalf of Mr. Haza.
Okay, sir, at this point, I'm going to be talking to you, but I will expect no response from you because Mr. Nava has entered a notice of appearance for both matters for you, and so he would do any talking for you. He's not going to want you to say anything. You understand that?
Yes, sir.
Okay. Anyway, you're here for two different matters. One is a probation violation. You know what you're on probation for. And for both of them, there's certain minimum release conditions. If you get out, contact your probation officer within 72 hours of release. No, you can't consume or possess any alcohol, no drugs without a valid prescription, and you cannot possess any weapons. That's common for both of them. All right. And Mr. Nava is going to be around to talk to you. He's obviously appearing by phone, so you can't talk to him privately now. But I just want to mention that to you. All right. Your court date on your probation violation is going to be at 201 West Jefferson for probation revocation arraignment hearing on June 22nd at 8:30. All right. In regard to the new case, and Mr. Nava, you'll have to take note of it, and so I won't explain to him how to do it. He's at the South Court Tower for status conference at the same time, June 22nd at 8:30. You'll choreograph that and making sure that there's no warrant on the other one because it can't be in two places at once. And his witness preliminary hearing will be June 24th at 8:30, at least at this point. Okay. So with all that in mind, and I told you release conditions. So let me, and just want to make something clear, Mr. Nava and Ms. Stetson, in regard to the new case, which is possession of weapon by prohibited person. Okay, I've made a condition he's not to contact his co-defendant, which is technically not a co-defendant, but they're both charged with possession of a weapon by a prohibited person, and they were allegedly in the same vehicle. So that's why I made that proviso, not to have any contact with the co-defendant. All right, so if anyone questions that. Okay. Ms. Stetson, I don't know if you want to speak on both the new case and the probation violation, or one or both. Okay, you've got the floor.
Thank you, Your Honor. The state was only intending on appearing on his new case, but the state would acknowledge that his new case is the same charge as his old case. So, Your Honor, do you want the state to make any statements?
It's up to you. It's up to you. It's up to you what you want to speak about.
Okay, Your Honor, at this point, the state will just be is prepared to speak about conditions on the new case, Your Honor.
Okay, go ahead.
Thank you, Your Honor. The state is asking for a bond in the amount of $10,000. This is based on the fact that the suspect is currently on probation for misconduct involving a weapon. Your Honor, the state was able to pull that up before court. It does look like that incident occurred back in November of 2023. So he is on probation for that. Additionally, Your Honor, the state did notice that he has a misdemeanor conviction for misdemeanor involving a weapon. The state did look into that, and it does look like that is more of a failure to disclose that he had a firearm on him. That looks like the violation for that occurred back in February 2023. Then he was picked up on his probation case, the case that he's on probation for in November of 2023. Your Honor, we're here in June of 2026 while he's still on probation for misconduct involving a weapon, and he is alleged to have been in possession of another weapon, which was located under the passenger seat of the vehicle he was in. The state would note that he said that he was not aware that the firearm was there. However, he does have a history of failing to disclose weapons, Your Honor. Part of his probation is that he not possess any weapons. But further, Your Honor, he is a convicted felon, so he's not supposed to have weapons in the first place. So that is the reason for the bond amount. Thank you.
Thank you for mentioning about the failure to admit a weapon, because I know that's a Class 1 misdemeanor and they had it listed under criminal history as a felony, and I know it's not. So you've confirmed that it's what I already suspected. All right. It's also interesting, by the way, Mr. Navi, you can even talk about it. They said for a total of 4 convictions, felony convictions. If I lift that one, I only see 2. I'm not sure what the third and fourth one come in.
That would be correct. That would be correct, Your Honor. I will note that I've represented Mr. Haza for quite a while. I know him. First, I will start that he is not the most sophisticated individual, and I've had to talk to him about a couple different things as they've gone through. I think that one of those felonies that they mentioned is actually an undesignated offense, which is what put him on probation originally. The misconduct involving weapons charge for which he is currently on is kind of a unique situation as well. He was placed on probation in the early disposition court. The court, as they often do in that situation, said, hey, you're on probation. I'm not going to read all your terms, but go through them with your probation officer. So we left that day from early disposition court. He contacted probation. Probation showed up at his house. And at that point, he said, oh, by the way, there's a gun that has been placed in my closet. I didn't know what to do with it. I'm telling you now. Probation charged him for that.
That's
No. This is the undesignated, Your Honor. This was the undesignated that is being treated as a felony for which he is, or no, I'm sorry, the felony for which he's currently on probation. That's this misconduct involving weapons that he's on probation. So this was sort of, and I don't want to say technical because obviously a technicality is still a violation, but this was a situation where, again, not being sophisticated, he waited until probation came, told them, and then they charged him with this misconduct involving weapons for which he is currently on probation. Now, there was a prior probation revocation hearing earlier this year that was since dismissed because I believe the underlying violation was also dismissed. But this goes to my point being Mr. Hayes is not a sophisticated individual. After reading the Form 4, although this is the same allegation as what he was on probation, again, it's a similar type of thing. He is saying, I didn't know this was in there. I don't know that the state is going to be able to prove this. I understand that it's not what we are here for, but I don't think that this warrants a bond, especially given that he has been in touch with his probation officer as early ago or as recently ago as 2 weeks. So he has been checking in. One of his probations was discharged back in April. I note that because in the Form 4, it states that Mr. Hayes has said, hey, I was discharged from probation. I think there was some confusion because on the same day, he was discharged from one of his prior undesignated offenses, but then reinstated, it looks like, after the petition was revoked on the misconduct involving weapons. So as an individual who doesn't understand the process very well, he assumed, okay, I'm off of probation. Now, that still wouldn't implicate his ability to own a firearm, possess a firearm, but I don't think that's what the issue is here. The issue is it was found underneath his seat, not even his seat necessarily, since it's not his car, but underneath the seat in which he was a passenger. I don't think that the bond is appropriate, especially because he has been complying with the terms of probation for some time now. He has not been revoked and sentenced to jail. He has not been revoked and sentenced to prison. He has been in touch with his probation officer. Again, this is somebody who I've represented for a while and I know will comply and has complied. Some individuals have terrible luck and don't ask the questions that they should, and I think Mr. Hayes is one of those individuals. I think that because, one, he has family here. He has 2 young daughters, one 20 months old, one 9 months old. He does work. He isn't currently working. His last job was 2 weeks ago, but that's because he does landscaping. Landscaping jobs do sort of dry up during the summer, but he is intending to get back on landscaping jobs as soon as he can. He is not a flight risk, Your Honor. He has all of his ties to the community here, including those 2 young children. He is not a danger to the community. There is no brandishing of a weapon here. Again, I don't know that the state will even be able to show or prove that he knowingly possessed this weapon. It was just found in a car underneath a seat in which he happened to be in. So we believe that a release to pretrial services on the new charge is appropriate, since he is on probation on the.
First of all, we don't put a person on pretrial services if they're on probation.
Perfectly fine. Then we'd ask for a release on their own recognizance, Your Honor.
Okay. All right. Thank you. One thing I have to tell you, obviously that's something for the state to see if they can prove their case. If they haven't, it's another story. Give me 1 second. I want to look at one thing in particular. I don't know. They're saying it was found on the floorboard, not concealed. I don't know how accurate that can be. Okay. And I want to check one other thing here. It's interesting. The other person in the car, it was found another gun underneath the driver's seat, and here a gun that's there.
Your Honor, if the state may,
Yeah.
real quick,
Sure.
the state was looking through just his history also. And the state just noticed that he was arrested last year for armed robbery, and there was 2 suspects, I guess, involved in that case as well, Your Honor, and there was also a gun involved in that case as well. Based on what I see, what the state sees, it looks like it was furthered by the state. So there is no charge, no conviction, but the state would just like to add that bit of information to Your Honor's, for Your Honor's knowledge. Thank you.
I know you're trying to provide that. I'd have, since there was no conviction, I'd be hard pressed to really consider that. But let's just look at this, by the way, both matters. I think that Ms. Navi, almost looking like he's doesn't recognize the fact when you on probation after the conviction of being a prohibited possessor, that you don't realize you're not supposed to have a weapon or not to ask the right questions, stuff like that. Of course, it goes to the issue of proof. So let me just deal with the probation violation. As I already told you, the court date is 6/22. The conditions. It's alleged to have violated term 1. And I'm going to reduce the bond I was going to set on that originally. It'll be a $1,000 secured appearance bond. You can go through the bondsman. Now, I know the state is asking for a, and this one is a $10,000 bond. I think that's too much. However, Ms. Nava, your argument, I don't have a copy. I do have APET's notes, since you bring that up. Okay, just for both parties to know, I've been looking at APET's notes. There are positive things in regard to that. I would tell you, Mr. Nava, I was inclined to do a $5,000 bond on that. But after reading those notes, I'm going to reduce it to $2,000. So you can add up the two bonds and he'll be able to get out. Obviously, you can raise those issues about reducing the bond if you're unable to post the bond at a later date in front of your assigned court. Okay. And as I said, he's due in court, two different courtrooms at the same time. So Mr. Nava, you'll take care of that. Okay?
Yes, sir.
There being nothing else, we are in recess. Thank you both. All right.
Have a good evening, Your Honor.
And just take care. He'll be in touch with you.
Okay.
That's gonna be, if he's ready. Mr. Mendoza?
We're ready, Your Honor.
Yeah. Hey, give me 1 second, sir. All right. So your name and date of birth, please.
Gilbert Lopez, 32293.
Okay. State announcer appearance, please.
Yes, Your Honor. Good evening. Ashley Stetson on behalf of the state.
Yes.
Good afternoon, Your Honor. Adam Weiner on behalf of Mr. Gilbert Anthony Lopez.
Okay, I noticed Mr. Mendoza signed it, so I put Mr. Mendoza's name as the assigned attorney.
Yes, he'll be the assigned attorney. I'm just the covering for the initial.
Okay, that's why I just want to mention.
Same firm.
Okay, Mr. Weiner. And sir, Mr. Weiner's can do all your talking for you. I'm going to speak to you, but obviously he'll speak for you, because otherwise he and Mr. Mendoza won't be happy if you speak. Okay?
All right.
Everything's being recorded. Okay. Now, just I let both attorneys know in regard to Mr. Sakurai. Even though they're both charged with, among other things, possession of weapons by a prohibited person. They're both in the same car, so they're technically not co-defendants, but I said no contact with each other as co-defendants. That's what I meant, not to contact each other. So I thought I'd let you know.
Okay.
Okay. Now, sir, I have not written down anything in terms of release conditions because I want to hear from both attorneys in regard to this. I have read through Form 4. You're charged with possession of weapon by a prohibited possessor, Class 4 felony, unlawful flight from a law enforcement vehicle, a Class 5 felony, and you'll be due in court at 175 West Madison Street in Phoenix for a status conference on June 22nd at 8:30, and the witness preliminary hearing is scheduled this time for June 24th at 8:30. You're not to return. Excuse me, I'm strike that. You're not to have any contact with any arresting officers. You're not to possess any weapons. And let's see here. Okay. Not to have any contact with any co-defendant, like I mentioned. You're not to consume any drugs without a valid prescription. Okay. just want to remind myself once again of the Form 4, because that was an extensive one.
Your Honor, may I be heard on public?
Yeah, I'm gonna talk to you both. in a
Okay, thank
second.
you.
I'm just outlining everything. And I would note that one of his convictions is possession of by a prohibited possessor, that type of situation. Yeah. Reminded myself exactly what I thought. Okay, let me hear from Ms. Stetson first, and then I'll hear from you.
In regards to probable cause, I thought counsel wanted to be heard on probable cause.
Oh, I'm sorry. I was giving him a chance to speak at the same time, but go ahead.
Yes, Judge, thank you. Your Honor, we do not believe there is probable cause for either of these counts. This incident, the alleged unlawful flight, allegedly occurred on May 28, 2026. There is insufficient evidence in this probable cause statement to support that our client was actually the person driving the vehicle. It is very unclear how they were able to identify our client. There's no evidence in here that they looked up the registration or the license plate and how they are able to identify it as Gilbert Lopez. There was a very vague description about observing a Hispanic male with light skin. That certainly could have been, millions of different people in this state of Arizona. Officers were not able to ever stop the vehicle on the date of this incident. They weren't able to to see who actually was driving the vehicle, to get a driver's license to confirm, and it just seems like it's pure speculation. And it seems improper. Just they're throwing out a name here without any actual evidence of how they came up with that name and date of birth.
Isn't that a triable issue? Because obviously what they're saying here, I'm looking at the Form 4 as you're speaking. They did recognize it was a silver in color BMW and cracked windshield bearing a certain Arizona license plate number on the west side. Using databases, they obviously look at the driver's license, et cetera, and they make the identification. So it does not goes beyond probable cause. It's a question about proof at trial. So I think we're beyond the probable cause in my mind.
I mean, I think given the fact there's probable cause that someone was unlawfully, fleeing the scene.
No, they're saying that's how they made their identification as why he was the suspect of the unlawful flight.
We need probable cause that he was actually the one from unlawful flight, and it's just not clear for me that how they came up to, you just see a random person, you're able to pull them up on your MVD records. I mean, this is something's not making sense to me there.
Right now, that's another issue, but the point is, obviously, they get a license plate number. My guess is they did some checking and to go into database.
So the vehicle's not even registered under his name.
I have no idea. Because they have other resources besides that, that they connected, and I won't go into that. But so I find probable cause.
If I may just, for the record,
Sure.
Your Honor,
Go ahead.
I just wanted to add a couple more things. The vehicle was stolen. It was reported stolen. So it's certainly, more than possible that someone else was driving the vehicle.
All right.
But I'll move on just to the.
As I said, I don't disagree with you, but my point is that's an issue for trial.
Okay. Well, could I just make just for the record as well?
Yeah, you said that. I'm saying I thought you were done with the PC part of that.
I just want to talk about the possession of the weapon as well. I haven't talked about that.
That's fine. I was done with it in terms of the unlawful flight. Go ahead.
Your Honor, again, the state needs to prove that he knowingly possessed the weapon. There's no evidence here that he knew the weapon. There's no admissions from him that he knew the weapon. There's another person in the car. He also said that it was the first time he was driving the vehicle. He says the BMW belongs to his mother, Joanne. Especially given how it's someone else's vehicle, it's very possible that, it was placed under there by someone else, and there's just simply no evidence to support probable cause that he knew that the gun was there, or that he even possessed the weapon, as the gun was never found on his person.
Okay, thank you. Once again, the issue is he was found under the seat, and obviously his passenger it was also found with a gun. He's saying it wasn't his either, that type of thing. That goes to the issue of proof. Obviously, the state would have a more difficult thing unless they perhaps do a fingerprint check to see if there are fingerprints on the gun, and that would be more proof. But obviously, that goes to the issue of proof, not for probable cause. In regard to that, it sort of reminds you of drug cases where they find it in the underneath the seats, same type of situation, or in the console, that type of thing. Similar situation. That's why I do find it was probable cause. I always ask the state first for bond recommendations, and then I do the defense. And so that's why I'm doing it this way, because you do have an opportunity to speak. All right.
Thank you, Judge.
Ms. Stetson, bond.
Yes, Your Honor. Conditions of release.
Yes.
Okay, thank you, Your Honor. And real quickly, the state would like to make a record in regards to some of what counsel said. Your Honor, as Your Honor stated, law enforcement did do a motor vehicle check on the suspect, and that's how they initially identified him. Yes, they identified him when he was driving. However, the Form 4 does indicate that the suspect was intended, the law enforcement did intend to make a traffic stop based on the cracked windshield, Your Honor. The suspect, where is it? The state believes that the suspect may have gotten out of the car at one point, and then they saw the suspect get out of the car, or that might have been the second incident, Your Honor. But the state believes there was more than one time that law enforcement was able to observe the suspect in the first incident. Your Honor, the failure to stop or the unlawful flight from law enforcement, Your Honor, that's indicative of the suspect not appearing at future court hearings, not being compliant with the judicial system. So those are part of the reasons why the state is asking for bond. Additionally, Your Honor, the state is asking for bond based on the suspect's criminal history. It does look like he has several prior convictions for misdemeanor misconduct involving a weapon, both felonies, Your Honor. He does have a prior unlawful means of transportation. That might have been from when he was a juvenile. He has an endangerment conviction. He has an aggravated DUI conviction. So for those reasons, Your Honor, the state does believe that given that this is his third misconduct involving a weapon, Your Honor, given the fact that he is fled from law enforcement, which in the state's eyes is like the state said, indicative of him not appearing at future hearings or not willingly coming into court. The state does believe bond is appropriate. State is asking for $20,000, Your Honor. Again, that is because this is his third. He has 2 prior convictions for misconduct involving a weapon. This is his third arrest for that charge, and all conditions outlined in the state's written recommendation. Thank you.
Okay, Ms. Stetson, one thing I must tell you, I only show 1 conviction for misconduct involving weapons. Okay, so just so you know, in regard to that, I see an endangerment, an aggravated DUI, and a drug charge. Okay,
sorry. Go ahead.
Go ahead. And I'm also seeing 4 failures to appear.
Okay. Yes. So I'm seeing that he has a misconduct involving a weapon from the date of violation was 2020. He was either he went to trial or he pled. Discharged from probation. Discharge from probation may have been, it looks like, received order of discharge felony May of 2026. And then he has this one right here, which is from 2022, Your Honor. Date of violation is 12/8 of 2020. They're from two different agencies, Your Honor, and it looks like there may have been May 2026 for discharge of probation. So it looks like from what the state's seeing, Your Honor, there's two completely separate CR numbers, CR 2022-000113-001 and CR 2021-141338-001. So for all purposes, Your Honor, the state is saying that there's two prior convictions, and he was very recently released from probation.
Okay. Now, Mr. Weiner. I'm sorry, we're waiting for you.
Okay, Judge, thank you. Yes, Judge, we would ask, I don't think a bond is necessary in this case, or we would ask that the court significantly reduce it to something more reasonable. There are, of course, going to be a lot of factual, issues that will be needed to address at a later time. Again, just to reiterate some of the main things that I said earlier, this vehicle was stolen. His mother did report it stolen. It was stolen for at least 4 to 5 days. Information I have, at least right now, it certainly, sounds like, whoever stole the vehicle is at fault for the unlawful flight in this case. I want to reiterate, our client does have prior criminal history, but he was released from probation. While on probation, he didn't have any issues. He was able to follow all the terms and conditions, which shows that, he will be able to follow any conditions that this court deems appropriate if he were to be released. He has stable employment. He is working at a warehouse. He has a place to live. He's currently living with his sister and helping each month to pay the rent. He has significant family ties here in the state, nieces, nephews, mother. He does currently have a 5-year-old daughter who he shares 50% custody with. He loves her more than everything, and certainly wants to be released so he can provide care to her.
Okay, I'm sorry. But while you both counsel was speaking, I'm also looking at other things on the thing, but obviously heard everything you had to say. One of the things I'm looking at, was concerned is also he has this, I'm only regarding him one prohibited possessor charge, but he does have 4 felony convictions. And then one of the key issue is, besides safety to the public, is also whether a person can show up for court. That's why I mentioned about the 4 failures to appear in regard to that. The only reason the vehicle stopped apparently is because it was disabled by the police. Of course, these are just allegations. It was a loaded weapon, et cetera. And a lot of issues the state obviously can do to bolster its case. But right now, this stage has said, I find probable cause. I'm setting bonds in a security appearance bond of $10,000. You can go to a bonds. We are in recess. Thank you. And counsel, if you want to speak to him back there.
Okay, thank you, Judge. I appreciate it.
And Your Honor, can the state be excused?
Yeah. Yeah. There was one case, but it's going to be a house call. We don't have to worry about it. Okay, take care. Bye.
Okay, thank you.
Roberto Hidalgo. All right. Sir, your name and date of birth, please.
Robert Hidalgo, January 1st, 85.
All right. You're here actually, one of them says it's a bench warrant, but it's actually a probation violation. So you have 2 probation violation warrants in 2022, 13759, 2023, 002-165. Okay. One is for an ag DUI, and the other one is a false statement to obtain benefits. I'm appointing a lawyer on both, and your court dates will be 201 West Jefferson on June 22nd at 8:30. If you get out, you must contact your probation officer in 72 hours. Can't consume or possess alcohol, no weapons, and no drugs without a valid prescription. Your judge and your probation violation court set bond in the amount of cash bonds of $1,000 each. So there's a total of $2,000 cash bond. If you have an issue with that, your attorney will talk to your assigned judge and see if that can be reduced.
I got one question, Your Honor.
Sure.
Is there any notes on it regards to
What's that?
any notes on there with, said by my public defender already appointed to the case?
Okay, I'll give you the courtesy of looking that up. Okay, 1 second. He just wants to get out, the attorney.
I can work to the copy. What's the vision?
Oh.
Writing that.
He's the one behind my case.
Hold on 1 second. See, the state board, because you were, in custody of DOC, you were at Alhambra, right?
Correct.
Okay. I see that. No, I don't see anything, any motions filed, other than by the state to bring you up from Alhambra.
Okay.
Okay. And obviously, sir, by setting the bond, you do get credit for these and possibly your prison term thing also. Okay.
Okay.
All right. Michael Ferreira. Oh, by the way, counsel, I just thought I mentioned he also has to up. 1 second. Before you do that, in Mr. Lopez, I think I put down, which I didn't sign yet, did I? Well, I didn't fill it out at all, did I? Thought I did. Oh, it got erased. Okay. Is it $10,000? He has to obey any terms of orders protection because it looks like there's one in effect. So, Mr. Lopez, you have to obey any orders of protection. All right. And now I'll sign it. Okay. Now she'll give you a copy of the release orders.
Judge.
Okay. All right, all right, sir, your name and date of birth, please.
Michael Ferreira, 7886.
Okay. Looks like you have a warrant at the city of Phoenix, so you're probably going to see a Phoenix lawyer tomorrow.
Huh?
Does he have a hold from Phoenix?
He does. Judge, it doesn't look like he does here.
I didn't take some typos.
I don't think it's a typo, just it's based on a violation of court.
No, I took some Tide Pods.
Pardon?
I took some Tide Pods. That was it.
No, this is a violation of court order, something. Now, sir, before you, I always advise people not to speak about the facts of the case today because everything can be recorded. So you say something, it could be, prosecutor could use it against you later on. Right, you are charged with aggravated assault, class 6 felony, shoplifting, class 1 misdemeanor, failure to obey a police officer, class 2 misdemeanor. I'm appointing a lawyer for you, as you were requesting that anyway. Your court dates will be at 175 West Madison Street for a status conference, June 22nd, and a witness preliminary hearing scheduled June 24th, both at 8:30. You're not to return to the scene of the alleged crime, initiate contact with the alleged complainant or witness. Bond is set security appearance bond of $1,000.
$1,000? I don't
Talk to your lawyer about seeing that can be reduced.
Huh?
Chad Miller. You can talk to your lawyer when you meet your lawyer, see if that can be reduced. Step to your left.
I'll move in.
All right, so your name and date of birth, please.
Chad Miller, 83086.
Yes, you're on probation, possession of dangerous drugs. You're alleged to have violated terms 3 and 5. You're on a probation violation. I appoint a lawyer for you. You'll be at 201 West Jefferson for his revocation arraignment hearing on June 22nd at 8:30. If you get out, contact your probation officer within 72 hours. No weapons, no alcohol, and no drugs without a valid prescription. A judge down in probation violation court said a bond, security appearance bond amount of $250. If you get out, make sure you contact your probation officer and show up for court. Jason Martinez.
Oh, this way.
Yeah, okay.
This way, you're done. Okay.
All right, so your name, date of birth, please.
Jason Martinez, 31480.
You also have a probation violation warrant, and probation for possession of dangerous drugs. I appointed a lawyer for you. You'll also be at 201 West Jefferson for probation revocation arraignment hearing on June 22nd at 8:30. You're alleged to violate terms 3, 5, and 15. If you get out, contact your probation officer within 72 hours release. No weapons, no alcohol, and no drugs without a valid prescription. A judge in probation violation court said bond for you in the amount of $250.
What's a probation violation?
Terms 3, 5, and 15. I should tell you what they are.
Hold
on a second. You're asking them. It was a teletype, and so they alleged 3, 5, and 15. Okay, I don't have it in front of me.
I just barely got out not too long ago, like 14 days ago, that I just did my time for a probation violation.
Well,
I'll be jailed and walking.
In April. And you were reinstated on probation February 23rd. Okay. So you can talk to your lawyer. All right, Desiree Slaughter. All right, your name and date of birth, please.
Desiree Slaughter, July 13th, 1992.
You're here on 2 probation violation warrants. I appoint a lawyer for you on both. You'll be at 201 West Jefferson for both of them on June 22nd at 8:30, 201 West Jefferson. And you're alleged to violate terms 3 and 5. If you get out, contact your probation officer in 72 hours. No alcohol, no weapons, and no drugs without a valid prescription. Now, in regard to the matter, in 2022, 130762, your judge down in probation violation court said bond in the amount of $150. In 2024, 137510, they set bond for you in the amount of $250. So your total bond is $400 security appearance bond. Step to your left, please. Anthony Losi.
Hello, Your Honor.
Your name and date of birth, please.
Anthony Alasi, 1384.
Okay, sir, you are charged with aggravated domestic violence, Class 5 felony, and interference with judicial proceedings, Class 1 misdemeanor. Now, you were actually asking for a court-appointed attorney, but I could not appoint one at this time. I don't find you're eligible. Now, you're going to try to hire your own, but if it turns out you can't, you can always petition your assigned judge to see whether he or she will appoint one for you. No promises in regard to that. Now, I'll tell you this, the state was asking for a bond of $7,500. I was reading the Form 4, and I was aware of the situation that neither one of you was following the order of protection, though it was directed against you. And she hadn't gotten around to having it quashed. So I'm going to give that, you still have to, as long as it's in effect, you have to stay away from there.
Okay? Absolutely.
So let's put it this way. Your court date, well, let me just talk back. You can't return to the scene of the alleged crime. You can come back one time with a police officer as a civil standby to pick up your essential belongings.
Yeah.
Let me just finish. You may return to the scene of the alleged crime and or initiate contact with the alleged victim only with prior written approval of the alleged victim and if there is no order of protection. Okay?
Okay.
Your court dates will be at 175 West Madison Street on June 30th at 8:30. Witness preliminary hearing is scheduled July 2nd at 8:30. Releasing you to pretrial services, you have to report within 72 hours to them. You'll get an envelope from the officer. Make sure you read it so you'll know how to contact them. Because if you don't keep in contact with them and do as required, a warrant will issue. And
Yes,
make sure
Your
you show up for court. Right? You'll be out in about 4 to 6 hours.
Thank you, Your Honor.
Okay. Joseph Murray. And so your name and date of birth, please.
Joseph Murray, 11698.
Okay. So you're charged with possession of dangerous drugs. I didn't see any lab tests, so I don't find probable cause at this time.
I had a quick question.
Let me finish.
Go ahead. Okay, I'm sorry.
Because if I speak, you may not want to say anything.
I'm sorry.
Okay. I can't find probable cause at this time. Doesn't mean you won't be charged with it, but at this point, I don't find probable cause. So you get released. Okay. But you still got to be, you're scheduled for court at 175 West Madison Street for a status conference on June 30th at 8:30 and a witness preliminary hearing. At this point, scheduled for July 2nd at 8:30. I don't know what's going to happen if charges will be filed or not, at least at this time. So check to see if you're supposed to be there, but otherwise show up, play it safe, right?
Understood.
So you're getting out, it'll be about 4 to 6 hours.
You said what was it?
You'll be out in about 4 to 6 hours. They have to process you.
Okay.
That's why I figured you probably don't want to say anything after I spoke.
Understood.
Okay. All right. Step to your left, please.
Thank you.
Blaken Hollenbaugh. Ball. So your name and date of birth, please.
Blake Hollabaugh, April 3rd, 2007.
You got an arrest warrant on the charge of possession of narcotic drugs, possession of drug paraphernalia. That's 4 classic felonies. Want a lawyer for you. Your court dates will be at 175 West Madison Street at 8:30. Status conference on June 30th at 8:30, and a witness preliminary hearing on July 2nd at 8:30. That'll be on your paperwork. You'll be released to pretrial services. You have to report to them within 72 hours and do drug testing. You'll get an envelope. Read that carefully. You know how to contact them and make sure you get your drug testing to avoid a warrant. Okay. Be out in about 4 to 6 hours. Okay. You can step to your left now. Brian Zufeld.
This is Superior Illustrations.
All right, so your name and date of birth, please.
Brian Zufeld, 610,000.
All right, so you are charge of a disorderly conduct and criminal damage, domestic violence charges at a Surprise City Court. The address will be in your paperwork. You got to make sure you show up there, which is July 14th at 1:30. You cannot return to the scene of the alleged crime. You're allowed to go back one time with a police officer on a civil standby to pick up your essential belongings. You're not to possess or consume any alcohol. And you can return to the scene of the alleged crime and/or initiate contact with the alleged victim, like it's your mom, but only if she gives prior written permission. Okay? And I'm releasing you on your own recognizance. I'm not appointing a lawyer for you at this time. All right, step to your left, please.
Thank you.
And the rest are house calls. I'll call the unit. Give me that slip of paper. Oh.
Your Honor, can you explain this guy? He was released on your court, but he has another court with Phoenix. It's a separate matter.
That's separate. Phoenix is a different judge. We don't.
So, am I getting released or not?
Well, it depends if you have a hold out of Phoenix. You have to wait till tomorrow morning to see a judge.
You have a bond. Phoenix has you up to a $230 bond.
That's something for Phoenix, not here. We're Superior Court. Okay. I have no control over that.
All right.
I didn't put function. Oh, the two are the state court. Okay. And these are house calls. Internally, bottom, it was on the suicide watch. Actually, he's charged with aggravated assault, class 3 felony burglary in the first degree, Class 3 felony, disorderly conduct with a weapon, Class 6 felony, burglary in 3rd degree, Class 6 felony, assault, and disorderly conduct, Class 1 misdemeanors. Appointing a lawyer for him. He'll be at 175 West Madison Street for a status conference on June 22nd at 8:30. At this point, a witness preliminary hearing is set for June 24th. State possession for a $50,000 bond, which I am going to impose, but also require, if he posts a bond, have an ankle monitor placed on him with a curfew. Can't possess any weapons. Have any contact with, return to the scene of the crime or have any contact with the alleged victims. Number 12 is Sheldon Wagner. It's got a grand jury warrant for aggravated assault. It allegedly occurred on 7/3/25. He's
For administrative segregation.
okay. You said unable to function. Oh, administrative segregation.
What's that? Or did they occur?
And it's aggravated assault. Appoint a lawyer for him. This arraignment will be at 175 West Madison Street, June 23rd at 8:30. Cannot have any contact with the alleged victims. Can't possess any weapons. Bond is set in the amount of, by another judge, in the amount of $50,000 security appearance bond. Then we have, well, Vida Pereira, who was apparently at 4th Avenue, I think in the psych area. Charged with reckless driving and exceeding the speed limit by more than 20 miles per hour. Justice Court warrant at Desert Ridge. His court date will be July 6th at 1:30 in Desert Ridge Justice Court. He's released on his own recognizance. Kenneth Palmer is also in the same situation. White's house call. He's charged with probation violation, a Class 3 felony. And let's see here. He's got a justice of the peace warrant on a excuse me, I'm sorry, he's got a probation violation, Mr. Palmer does, on a Class 3 felony. And his revocation arraignment hearing will be at June 22nd at 8:30, 201 Jefferson. If he gets out, contact his probation officer within 72 hours. No weapons, no alcohol. And bond set amount of $5,000. Okay, we are in recess, right?
I need to search your booking tickets are printing in here.
All right.
Thank you. This is seated.
Is our interpreter.
And the one for
Okay.
and then should be is here for number 7.
Okay. And then we have the council here.
Defense counsel for number 18.
Okay. So do we have the interpreter right now?
Okay, we'll do this after the call.
Okay. So they typically wait until the end to do that? They.
This date is also going to be assigned
For number 18. Okay.
Okay, this is the 11 p.m. initial appearance calendar. It is June 15th, 2026. Before we start, I have 2 advisements to read. First, if you're the victim of a crime with a case pending before this court, please be advised that you have certain rights under Arizona law that include the right to be treated with fairness, respect, and dignity, the right to a speedy trial, to be present at court proceedings, to choose whether or not to be interviewed by the defense, to be heard before the court makes a decision on release, on the negotiation of a plea, on scheduling and sentencing, and to receive restitution from a person who is convicted of causing you loss. If you have not received a written statement of these rights, please contact the Victim Services Division at the prosecutor's office. And second, the court notes that the orders for the taking of DNA and fingerprints that were given on the first calendar of this month shall apply to all matters in this calendar. So, ladies and gentlemen, this is your initial appearance. I'm going to be calling you each individually into the courtroom. So please, if you would, just listen out for your name to be called. When you do hear your name called, kindly make your way to the center of the courtroom, to the podium. I will also let everyone know who is going to be second in line. And if that person could please take a seat in the chair immediately to the left of the doorway, that will make everything much more efficient. When you're in the courtroom, we will go over several things. I will let you know what the nature of the matter is that you're being seen on, whether or not the court is able to appoint an attorney to represent you at no cost, at no or little cost. I'll let you know when your future court dates are and whether or not you are eligible for release. If you are eligible for release, I will go over the most important release conditions with you here in the courtroom. It's very important to note that I will likely not go over every single one of those release conditions, but all of those conditions, as well as your next court dates and times, will be on your paperwork. So please make sure to grab your paperwork on your way out of the courtroom. Don't lose it, and make sure that you read it in its entirety, because you will be expected to follow all the release terms in that paperwork. All right. So with that being said, we will start with Ruben Alvarado, and then if I could have Quentin Howard to the seat by the doorway.
Thank you. Morning or evening, Judge.
Thank you.
Thanks for agreeing to see us at 11.
Of course.
Appreciate it.
All right. So I believe I also have counsel for the state, right?
Your Honor, state is present.
Okay, fantastic. We will go ahead and start. Mr. Alvarado, could I have your name and date of birth?
Ruben Alvarado, 10-0507.
Okay, and counsel?
Kellen Marlowe on behalf of Mr. Alvarado, Judge. We entered a notice of appearance on June the 10th of 2026.
Fantastic. And could I please have counsel for the state?
Yes, Your Honor. Good evening. Ashley Stetson on behalf of the state.
Okay. All right, so let me tell everyone what my understanding is on this matter. So, Mr. Alvarado, my understanding is that you are on probation for armed robbery and endangerment, and that this matter is basically a warrantless petition to revoke that probation for an alleged Term 1 violation, and that would have followed the charges, I believe, that were ultimately filed from the incident that occurred on April 21st, 2026. Do I have that right, counsel?
That is correct, Judge.
Okay, and state, is that your understanding? Okay. So, Mr. Alvarado, you do have a probation revocation arraignment and possible disposition hearing on June 23rd at 8:30 a.m. All right, and that date and time is in your paperwork. And before we address release conditions, does counsel want to be heard on that?
Yes, Judge.
Okay, so let's start with you.
Judge, top line for you, my client received bad advice. He had an initial appearance with me on June the 4th of 2026. At that time, he was released on a $2,500 secured appearance bond in the probation violation matter from in the 2024 case. And I believe he's released on a $5,000 secured appearance bond in the 2026 matter that was eventually indicted by the state. A status conference was set in that matter on June the 11th at 8:30 a.m. in early disposition court in the South Court Tower. And then the probation revocation arraignment was set on June 11th at 8:30 in the Central Court Tower. And Judge, we followed the proceedings through the week. We did enter a limited notice of appearance at the initial appearance. Subsequently, we were hired by Mr. Alvarado to represent him on both the probation revocation as well as the new charge, like I stated, which was indicted in this case. I understood and we confirmed that the status conference was vacated in the matter when the state sought an indictment and obtained an indictment in the case, and that status conference on June the 11th was vacated. I met with Ruben on June the 10th, the day before, and frankly, not understanding that he had actually two separate hearings set at the same time, but in two separate courts in regard to the two different matters. I advised him at that time that he did not need to appear for court. He had a not guilty arraignment set for, I believe, this Thursday, June the 18th at 8:30 a.m. His not guilty arraignment at the South Court Tower. Judge, my client failed to appear for his probation revocation arraignment last Thursday because of poor advice on my part. And we're asking to affirm the current secured appearance bond of $2,500 that he's been released on to this point. No further bond is necessary to ensure his continued appearance in this case. This isn't a new charge that he is being brought in on. This is simply a failure to appear on the bad advice of his counsel. That would explain his failure to appear at his probation revocation arraignment last week. Again, just please affirm the $2,500 bond he's currently released on. It's a secured appearance bond. I'd also ask you, Judge, if you can, I understand he's got a probation revocation arraignment set on June the 23rd. I don't know if the court has the power at this point, but if we can align that with his not guilty arraignment date set for this Thursday at 8:30 a.m. in the CR 2026 matter, I think that would avoid a lot of the issues. I can tell you counsel, or I won't say counsel speaking in the third person, I understood that both matters would be set at the same time, and I didn't review his release paperwork in close enough detail to see that it was two different courts. If we can get those dates aligned, Judge, I think that would help both of us out. That's all I have, Judge.
Okay, well, I appreciate that explanation. I appreciate you appearing today in person, so thank you for that. And counsel for the state?
Thank you, Your Honor. And Your Honor, the state is not the attorney of record for either matter, Your Honor. Due to the lack of information the state would just ask that the bond be affirmed, and counsel can address this with the assigned prosecutor. Thank you, Your Honor.
Okay, thank you. I'm just going to check with my clerk about that date. Okay?
That'd be great, Judge. Thank you.
Is there anything we can do about that?
Unfortunately, we only have preset dates that are actually go but we can commit a motion to probation court and try to see if they can get that situated.
Okay. All right. So unfortunately, there's nothing I can do right now about that date.
We can figure that out, Judge. Thank you.
But the court will affirm the $2,500 bond at defense counsel's request. And just make sure that you read over the paperwork, okay? Because it includes a full list of release conditions that I'm not going to go over right now. But read that and make sure that you get this taken care of, okay?
Okay. Thank you, Judge.
Is there anything else from either counsel?
Judge,
No.
Ms. Stetson,
No, nothing further from the state, Your Honor.
Okay.
Judge, I'm going to read this paperwork, Mr. Alvarado, right now in a little bit more detail than we did the last time. We reviewed his release conditions previously when he came to my office on June the 10th. He's well aware of what he needs to do. He's going to get in contact with this probation officer. I've already been in contact with her as soon as he's released from custody today, and you won't see him back here again.
Okay.
Thanks,
All right.
Judge.
Thank you so much.
Thank you, Judge.
All right. So may I please have Quentin Howard, and then we'll have Kirby Wilson next. Yeah. Oh, it didn't? Okay. Oh, I'm sorry. Okay, we should be good. All right, may I please have your name and date of birth?
Quentin Michael Howard, February 9th, 1986.
Thank you so much. And counsel for the state, you're appearing on this one, correct?
Yes, Your Honor. Commissioner Bernstein had him on his 8 p.m. calendar, and he asked the state to look into this issue and see if they could provide, I could provide the court with any additional information. But for the record, Your Honor, Ashley Stetson on behalf of the state.
Okay, thank you so much for appearing. So Commissioner Bernstein did let me know what was going on, okay, and so he asked the prosecutor's office to look into seeing whatever information they could pull up on this. So, counsel for the state, if you could just fill me in on anything that you have.
Yes, Your Honor. As soon as the state got done with appearing on the 8 p.m. calendar, the state did reach out to the assigned prosecutor on this case. The state did have the opportunity to speak with the assigned prosecutor. Mr. Miller did inform the state that the suspect had originally appealed, I think it was an armed robbery charge, maybe, Your Honor, a robbery charge. He did appeal the robbery charge. The appeal was overturned, Your Honor, and it was sent back to the lower court. So that's why he was re-indicted on it.
So this is already taken care of, like, because I went to court this morning with Judge Susan Nichols, and we already set like a date. So this is the same case then, right?
So
'cause that was my appeal. I've been in custody for 2 years already without being released.
Okay.
So they transferred me here from Cheyenne Prison in Yuma
Okay.
Thursday, and then I had court this morning for my appeal because my appeal got approved for robbery. So they said a matter for like the 23rd, I think, of this month for me to go back and appear in front of Nichols. I'll go back to my pod. They said I get page 2. When I come down here for the fingerprint, I asked her, what's my charge? She said robbery. I'm like, that's what I'm already booked on. And then I asked, what's the date? She said February 2nd of 2026. I said, that's the same date that my original, when I'm being held on this charge of robbery, is the same date of the event that happened. So here we are.
Okay. And counsel for the state, were you able to hear all of that? And do you have a response to that?
Well, Your Honor, I'm stated looking at the warrant. I think it's the warrant. Yes, the arrest warrant, Your Honor, and it looks like that arrest warrant, which is a grand jury warrant, is what the suspect was being brought to court today for. It looks like it was signed on the 12th. The state doesn't have any information about whether or not, about his earlier hearing today, I think he said, but like the state said, he is being re-indicted on this, given the fact that his appeal, the Court of Appeals, it overturned his original charge. So it was the only thing that the assigned prosecutor said to me was that he was re-indicted on this matter, and there were sent down from the Court of Appeals to fix a few things. That's the only information that the state does have.
So this is the same case.
Just give me 1 second, okay?
All right.
And so when are your next court dates?
I don't quote me on this for sure, but I believe it's on the 23rd of this month.
Is there any way that we can pull up FCR that the correct what's the answer?
Judge, they did say that this case is being retrialed. I heard that in court, so I don't know if that term changes my appeal or anything like that, but overall, I know this is the same case, the same event. Does that make sense?
Sure. So
all right.
You were in prison on this matter.
I got arrested February 2nd, year 2024.
Okay.
And I went to trial in April of 2025. And then I got sentenced to 3.5 years on a lesser included offense of robbery from armed robbery with a use of deadly weapon, because I got a hung jury on that. So May, I get sent to prison. I had left behind filed for an appeal.
Mm-hmm.
So it's been since May of 2025 up until last Thursday. I get pulled from prison, come here. I appear in court Monday, today, for robbery to appeal that. And I guess they said now we're going to retrial it because my appeal got approved. So then when I come back for like an hour, I get page 2 on a robbery with the same offense date of February 2nd of year 2024.
Okay. So yeah. Okay. I don't have access to on me or whatever. Oh yeah.
Do you want me to print what I can get from his 2024? Because that's the one that I noticed that it does have the appeals and everything.
Okay. Can we pull up with a minute entry available from Monday's hearing master?
The last thing that we saved for this one, it looks like.
Your Honor.
Yeah, entry for Thursday.
It looks like on not the new case, but on his appealed case, it looks like from what the state can see, his next hearing is June 25th at 9:10 a.m. But and he had a hearing today at 10 a.m. So that is correct.
Okay, so, that does make sense to me. The court still has to set release conditions, okay, on this. So I'm guessing that...
We're labeling this as what?
So because this is the initial appearance on the new indictment.
Okay, which is my appeal that I went to court.
Right.
So this is not like 2 cases. This is the same case.
Yes, exactly. So yes.
So this is a process we're doing.
Yes. Yes, this is a process that we're doing. So all of that makes sense. So, basically this is the release conditions on the new indictment for the same case.
So can you OR me right now? Or what?
No.
Why not?
All right.
I've been in prison 2 years.
So, okay. So when let me just pull this up really quick. Thank you all, by the way, for your patience on this. I appreciate it. All right. So when the grand jury indicted you for 1 count of robbery, class 4 felony, 1 count of shoplift, with predicate convictions of class 4 felony with the date of offense, February 2nd, 2024. They did that on June 12th, 2026. When that June 12th, 2026 indictment came down, the grand jury requested a cash bond in the amount of $10,000. Okay. So for today's purposes, this court is affirming that cash bond.
So question, so I get, this is mind blowing to me. Maybe you can make sense to me real quick, because you're talking about release conditions. I went to trial on this case and I got released from prison. So it's like, you know what I mean? And I got an appeal for this case. I'm released from prison, like my prison sentence is over. So like if I leave here, this is all done, because this is all the same case and I'm trying to figure out how am I released from prison and then have this case and I can bail out and dip out and there's no parole, no probation, nothing.
Well, it's basically like you're starting over with a new case. So procedurally, you know, we start over with the release conditions. Okay. So for now, it's a cash bond in the amount of $10,000. You have some other release conditions. All of those will be listed out in your paperwork. Okay. And you have your next hearing. It's just in about a week. You know, you can certainly talk to your attorney about that.
Yeah,
okay.
This is kind of.
It does get procedurally complicated when there are appeals. Okay. So I appreciate your patience.
Thank
and all of that will be written down for you. Okay.
Okay.
Okay. Thanks.
So my next court date is 10/25, right?
June 25. June 23rd. Okay. So there may be court dates that are set as a result of this initial appearance, and then it sounds like other court dates that are set with your trial court judge already.
Right.
So your first one in line is the June 23rd date, and your attorney can help sort out whether that is necessary or, you know, how that coincides with the June 25th date.
So the 25th is something that Nichols said.
It sounds like it.
And the 23rd is what you're saying?
Yes. Okay.
And this, so.
Yes. So your attorney will help you coordinate those.
So all this is going to come together in one thing.
Yes.
Okay.
Okay. All right.
Cool.
Thanks so much. And counsel for the state, thank you so much for appearing. Do you have anything else to add?
No, Your Honor. State would be asking to be excused unless Your Honor has any other matter.
Oh.
Thank you.
Okay. Take care. Thank you. Thanks. All right, Kirby Wilson, please, and then Hazel Summers. All right. May I have your name and date of birth?
Kirby Wilson, February 27th, 1998.
All right. You're here on allegations of new offenses. So specifically, they are 2 counts of aggravated assault. It's class 2 felonies. 1 count of disorderly conduct with a weapon as a class 6 felony, and 1 count of threatening and intimidating as a class 1 misdemeanor. The court has found that probable cause exists as to all of those allegations. The court is appointing an attorney to represent you. You have a status conference on June 22nd and a preliminary hearing on June 24th at 8:30 a.m. The court notes that there were victim impact statements that were filed in this case that the court has considered. So you are eligible for release. The court is releasing you on the following terms. You have a secured appearance bond in the amount of $100,000. If you post that bond and are released, you will be released to pretrial services on an ankle bracelet, and you will effectively be under house arrest with that, right? You have other very important terms of your release. You are not to return to the scene of the alleged crime, and you're not to have any contact whatsoever in any form with any of the alleged victims or witnesses. Do you understand that, sir?
Yes.
Okay. Additionally, the court is ordering you not to possess any weapons, no drugs without a prescription, no alcohol, no driving without a valid license. And just like I've told everyone else, make sure to read your release paperwork for a full list of release conditions. It's very important that you comply with each and every one of them. All right?
Mm-hmm.
Thank you so much. That concludes your hearing. One of the deputies will give you your paperwork.
Thank you.
Hazel Summers, and then we will have Stephen Adams Lawrence.
It's 5/16/2003.
You're here on allegations of new offenses, Ms. Summers. They are 2 counts of disorderly conduct as Class 1 misdemeanors, 1 count of assault as a Class 3 misdemeanor, and 1 count of criminal damage as a Class 1 misdemeanor. The court has found probable cause as to all of those allegations except for the allegation of criminal damage. From the limited information that I have from police at this point, I just don't have enough information to find probable cause. That's not to say, though, that you won't ultimately be charged with it. The court is appointing an attorney to represent you, and you have an arraignment hearing on June 18th at 9 a.m. You are eligible for release, and the court is going to impose some release conditions for you. The court does note that the court has some concerns, okay? I see here that you have a conviction for criminal damage, and that sentencing date was only on June 9th, 2026. And you appear to have gone through some sort of court diversion for a domestic violence disorderly conduct in 2025. I also see that you have 2 open cases out of Glendale Municipal Court for domestic violence offenses. So it's going to be very important that you comply with these release conditions because it will only get worse if these types of things and allegations of these types of domestic violence incidents keep happening, right? The court is imposing a secured appearance bond in the amount of $5,000, right? And that's because of that history that I just read over to you, all right? And it's just going to get more and more serious if this continues to happen.
I did have court, like, right before I got taken. I don't know what the plan was, if she was going to take me or not, but I got taken as I was on my way to court for this morning.
Okay, and I did see that, okay? So additional terms of your release are you're not to have any contact with the alleged victim, okay? You can't have any contact with any witnesses, and you are not permitted to reside at the same location as okay, all right. So additionally, no weapons, no drugs without a valid prescription, no alcohol, and please see your written orders for the full list, okay? All right, that concludes your hearing.
Okay, thank you.
Okay, we're just gonna take one quick break here. All right, I'm sorry about that. So we will have Stephen Adams Lawrence in the courtroom and Jesus Rodriguez up next. All right, may I have your name and date of birth?
Stephen Lee Adams Lawrence, 9382.
Thank you so much. So, Mr. Lawrence, you are here on one matter. It's a probation violation arrest warrant. It's in your 2024 criminal case where you're on probation for possession of narcotic drugs for sale, which is a Class 2 felony. You have alleged to have violated terms 3 and 5 of your probation in that matter. The court is appointing an attorney to represent you. You have a probation revocation arraignment and possible disposition on June 22nd at 8:30 a.m. You are eligible for release. The court is imposing the following terms. You have a $1,500 secured appearance bond. Okay. In addition to that, some of the other release conditions include no weapons, no drugs, no alcohol, no driving without a valid license. You've got to contact your probation officer within 72 hours. All right. So I frankly, this warrant issued back in 2024, I really considered a higher bond amount. But I'm hoping that you use this as an opportunity just to contact your PO, go to these next hearings, and get back on track with your probation. Okay? All right. That concludes your matter. Thank you. Jesus Rodriguez, and then we'll have Reed Hope. Hello. May I have your name and date of birth?
Jesus Rodriguez, December 6, 1999.
Thank you so much. You're here on two matters, okay? I'm going to go through them one by one. So, in the first matter, you're here on basically a bench warrant that issued when you failed to appear for a hearing in your criminal case where you have one count of possession of narcotic drugs and one count of possession of drug paraphernalia. The court is appointing an attorney to represent you. You have your next hearing on June 22nd at 8:30 a.m. You're eligible for release. Some of your release terms include the following. You have a secured appearance bond in the amount of $500. If you post that bond, you'll be released to pretrial services. You'll get information on how to contact them. Some other terms of your release are no weapons, no drugs, no driving without a valid license. See your paperwork for a full list, right? And in your second matter, you're here on another bench warrant that issued when you failed to appear for a hearing in your other case. In that case, you're charged with one count of possession of dangerous drugs. The court's appointing an attorney to represent you in this second matter, and you have a status conference in this one on June 22nd at 8:30 a.m., and then you have a preliminary hearing on June 24th at 8:30 a.m. So in this case, some of your release terms include a secured appearance bond in the amount of $500, okay? And just like in the first case, if you post your bond and you are released, you'll be released to the supervision of pretrial services. You have additional terms of release in this case to make sure that you really
What do you call them when I get out?
I'm sorry, what?
What do you call them when I get out? I call them when I get out in 72 hours.
So, that's not, so no weapons, no drugs, no alcohol. keep the court notified of your new address, okay? But make sure that you read all the terms on the list, okay? They're all written down for you. All right, that concludes your hearing. Thank you. You may step that way, get your paperwork. Okay, great. How do I do that? Do I just?
Yeah, I'll transfer it.
Oh, okay, okay, great. Thank you so much for getting him on the line. All right, read Hope, please, then Fernando Morales. May I have your name and date of birth?
Reed Love Hope, 1294.
Thank you. All right, I have you here on one matter. It's a probation violation arrest warrant. In your case where you're on probation for possession of dangerous drugs. You're alleged to have violated terms 3